Morning, Larry. Can I do a volume test?
Good morning, Michael. How are you this morning?
Good, thanks.
Good. Laura's having a little technical difficulty. We're going to go ahead and start, and then she'll be joining us somewhere in the front end of the agenda.
Okay, thanks.
The sound volume is good, Mike. It sounds real good. But mine?
Yeah, you're fine.
You sound, yeah.
Mr. Chair, we're on the air whenever you're ready to begin.
Okay, very good. Thank you, Mr. Villalobos. Good morning, everyone. Welcome to the May 26th meeting of the Santa Barbara County Planning Commission. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, Mr. Villalobos, could you handle items 2 and 3, please?
Thank you, Mr. Chair, and good morning to the Commission. Planning Commission hearings are televised live on County of Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, Santa Maria, and Orca areas. Rebroadcasts of Planning Commission hearings are on Fridays after 5 p.m. on CSB TV, Channel 20. Today's hearing will also be streamed live on the county's website and will be available for download in a day or two. Moving to the roll call, Commissioner Cooney.
Here.
Commissioner Blau.
Here.
Chair Farini.
Here.
And I believe Commissioner Briley will just be joining us shortly, as well Commissioner Park will be joining us later this morning.
Thank you, Mr. Villalobos. And Mr. Wilson, good morning. How about items 4 and 5?
Good morning, Chair and Commissioners. In regards to the status of our agenda today, we have 4 items that are listed on our standard agenda. The continuance of the Keyside 3 residential subdivision project, and then an appeal of a homestay application, and then an appeal of a mixed light cannabis cultivation, and then another cannabis cultivation project. However, the Commission's information, item number 3 has requested a continuance, and it's being recommended that that item be continued to June 30th. For the applicant to continue to coordinate with the appellants on some issues that were identified. With that continuance request, I would leave us with 3 items, and staff is ready and prepared to present on those items today. And we can move on to the projection report. Mr. Chair, if that works.
Yes, please.
In regards to the projection report, our next scheduled hearing is June 2nd. We have 3 items listed on that agenda. The Ramey recorded map modification, the appeal of a G&K cannabis processing, and then another cannabis appeal, Sun Valley, on that date. And I believe that there will probably be a request to continue the G&K cannabis project to another date on that. So we'd probably only have 2 items on June 2nd. The next meeting after that will be June 9th. We have 4 items listed on that. The Summerlin project was continued June 9th. We have the appeal of the continuance of the Jackson appeal of the Amador homestay. And then we have the Santa Rita Holdings cannabis project. And then the appeal of it's already shown on there is that G&K based on their request to continue that one. And then our next hearing after that is June 30th. We had scheduled the continuance of the Keyside 21 to that date. And then July 7th, we have Cresco Cannabis Cultivation Project. And then moving down to June 28th, we have the projected the Orchid gas station, the appeals of that project. And then one thing that we do need to update, and the agenda doesn't go out that far, based on some financial coordination with the applicants for ExxonMobil, there was about a month delay on that project. So we're asking the commission to cancel the August 13th special hearing, and then that item will be moved to September 8th, and then we'd ask for a special hearing to be on September 10th. So it's basically 1 month delay on that project. So that concludes the projection report. And then I believe Director Plowman in her director's report will go into more details as far as COVID-19 and hearing formats. That's something that we're continually coordinating on in our office, and she can provide some more insight on that as in her report. So that concludes the projection report. The action then requested is cancel August 13th special hearing and then set a special hearing for September 10th.
Okay, Commissioner Blau.
Yeah, I just want to make a comment about the continuances and the way we kind of do the meetings, giving us a little bit of thought. I think it'd be appropriate that we take the projects out of order. If someone's requesting a continuance, put them first before we do anything else. My thinking here is that if you're on item number 3, if there's anyone in the audience that wants to speak to it, they don't know if it's going to get continued or not until it comes before us. That seems to be a little bit unfair. And I wouldn't expect them to leave just because someone asked for continuance, because in the past, sometimes we don't grant them. I'm just thinking as a procedure, if there's a continuance being asked for, let's do those as soon as we can, first thing. That way you can go ahead, and I would not do a staff report. I would just read the record and ask if anybody wants to speak to the continuance. If they don't, then we make a decision to continue it or not. And by the way, if we don't continue it, it can go back up to item number 3 or 4 whenever it's there. But I just hate for people to be sitting in the audience in the near future, having to sit there, or even the participants not knowing what actually we're going to take until after lunch. It just doesn't seem to be an appropriate way to conduct business. So I would like to see us, if someone asks for continuance, we do those right away, so that if it's going to be continued, people can, get off the phone or get off the television or get off the computer or go home. So that would be my suggestion.
So that would be Commissioner Blau. So when we get to the standard agenda, then we'll move the agenda around. Is that how you see it?
I think that would be great. I think it'd be really great for the audience and the people that participate in it.
Okay, well, let's give everybody a few minutes to think about it. I think it's a great idea, and when we get to the standard agenda, we'll bring it up. As far as the Exxon continuation, I think we need a motion now.
Yes.
Commissioner Cooney.
I will move that we we vacate the Exxon hearing on the 13th of July, August, 13th of August, and move it forward as suggested by staff to September 8th, and also agendize September 10th as a special meeting on the Exxon trucking project.
And I will second that.
Okay, thank you. And good morning, Commissioner Bradley. Welcome. Glad you could get all hooked up there.
Yeah. Yes,
Okay,
thank
great.
you.
Okay. All right. So, Mr. Villalobos, can we move on to a vote, please?
Commissioner Cooney,
Aye.
Commissioner Bradley,
Aye.
Commissioner Blau,
Aye.
Chair Freeney.
Aye.
Motion passes 4-0.
Okay.
Mr. Chair,
Yes,
I know I'm late, but I did want to bring up one thing, and this might be the most appropriate time to do that under projection report, which was during the public comment and the site visits and everything for today's agenda on a couple different cannabis cases. What occurred to me was if the commission would be interested in having a kind of a briefing from the 4th floor in the business license office. Because what we're hearing as cases are moving from planning and development into, the business license before they actually start operating, we're hearing new information about what that is and how, and I'm not kind of interested in the statistics of how it's going. How do they get out of planning into business licensing? We have a lot of discussions on all cases about who's complying or how permit compliance is happening with PMD versus business license. And we had that discussion last year during our workshops and a little bit later. So I'm wondering if there's any way at a time on the agendas when it's convenient for everybody, that we have an item with the fourth floor about that.
Secretary Wilson, I thought I heard you say that G&K was probably going to continue their June 2nd hearing.
Mr. Chair,
Room to invite the CEO's office in.
Mr. Chair, I can, I'll reach out, I'll coordinate with the CEO's office on the business license and see if that date will work. Otherwise, if not, we can, there's other dates later in June or July that we could potentially have them scheduled. So I'll coordinate with them and report back at our next hearing on a date.
Okay, I would just say, adding on to Commissioner Bradley's thoughts there, I think it's an excellent idea. We can use this agenda, as we could say, to help inform the public, because there is a lot of concern, and it does come back to the Planning Commission, but it's not really our department. So I think the sooner the better for public concerns.
Yeah, I'll reach out to the Brittany Heaton in the CEO's office in regards to a presentation. June 2nd may be a little aggressive for them to put together some information. I know they do briefings to the board on a quarterly basis, but I think what you're asking for is a little bit more detail. So I think June 2nd may be a little aggressive for them to be prepared for a good presentation. So we might want to look at maybe mid to later June on that one.
Okay.
Thank you.
All right. Commissioner Cooney, your hand's still up, and Commissioner Blau. Comments, sir?
Mr. Chair, I was leaving my hand up to continue the other item we were talking about from G&K from the 2nd to the 9th. It's on both places in our projection report. And I think the 9th is the date requested by the applicant. So that would be my motion.
Mr. Chair and Commissioners, if I can just interject real quick. On a procedural item, so that was continued to a date certain, which was June 2nd. So we'll have to take up that continuance on June 2nd. So as much as I would love to do the efficiency in moving it today, I think because of noticing, it was actually continued to June 2nd. And then on June 2nd, we'll actually pick up that request for continuance.
Okay, thank you, Mr. Wilson. Commissioner Blau, and you are muted.
Yeah, I just want to add on to Commissioner Bradley's comment for the business license. I'm particularly interested in having Ms. Plowman or Mr. Wilson and whoever from the business licensing kind of give us a detail, which is each of the parties' responsibilities. I'm curious that we don't try and overlap our conditions of approval with something that's handled by the business licensing. So if we could understand what's their responsibility and what ours is and try not to overlap, I think that unconfuses the public and unconfuses the applicant and even the appellants. I mean, sometimes they come in and ask for conditions of approval that are not appropriate for planning to do because they're handled by business licensing. So if we could get a concise, division of what they do and what we're supposed to do, I think it'd be really helpful going forward.
I think so too. So let's we look forward to that. Okay. On to public comment. If there's anyone from the public who would like to speak today on items not on the agenda, now would be the time. Mr. Villalobos.
Mr. Chair, I had, as of last night, a maybe.
Okay.
Ms. O'Neill, did you wish to speak for general public comment this morning? So for the record, that would be Renee O'Neill, who indicated that she wanted to speak on items number 3 and 4 and perhaps general public comment. So Ms. O'Neill, I've allowed you to speak. You just have to unmute yourself if you'd like to comment. Mr. Chair, I'm not hearing a response from Ms. O'Neill.
Okay, is that a *6 she has to press or something, or?
If she's joining by phone, she has to hit *6, but I'm not sure how she's connecting to the meeting today.
Okay. Okay, is there anyone else, Mr. Villalobos?
No one else for general public comment.
Okay, well, we'll move on from public comment then and move on to Planning Commissioner's informational reports. Nada, okay. Let's move on to the minutes then of April 28th. I don't know if you want to do them all at once. We have April 28th, May 5th, and May 12th.
I'll move for approval of both.
Commissioner Cooney?
Well, there are three, right? April
Yes.
28th and then the 5th and 12th of May. Commissioner Blau, are you moving approval of all three sets?
Yes, I am.
All right, I'll second.
Okay.
Uh,
Yes, Commissioner Bradley.
Chair, I'm not electronically with it this morning, but on the minutes for May 12th, I just had Commissioner Cooney will be proud that I do proofread sometimes. I found a little thing under item 3, the action, the last line under action, I think it should be requested, ED, that staff draft, not ING, findings for denial.
Good catch.
And then also on the action, I believe that Commissioner Blau was absent, not that he voted no on the next page, top little paragraph. I think he had to leave that hearing, right? So it's a 3-1, Cooney no, Blau absent, right?
Correct.
Okay.
We'll
Thank
put you
you.
in for a bonus.
I might get the Cooney Award for period placements. Yeah.
Okay, Mr. Villalobos.
Commissioner Cooney,
Aye.
Commissioner Bradley,
Aye.
Commissioner Blau,
Aye.
Chair Farini.
Aye.
Motion passes 4-0.
Okay, great. Thank you. And on to item 9, Director Plowman, the director's report.
Yeah,
Ah,
sorry. Good
Join the
morning.
club. Join
Right?
the club.
Too many taps on the stop video key. Good morning, Mr. Chair, members of the commission. I'd like to give you an update today on COVID-19. It's kind of a ever-changing landscape. But the state, as we talked about, is basically opening its doors on 6/15 and lifting a lot of the restrictions. And we will also be opening our doors on the 16th, the 15th of June, but we're still waiting to hear from OSHA. Initially, they made a determination that we would continue to follow the physical distancing and mask wearing guidelines until the end of July, but it appears they may be reconsidering that. So we hope to hear by the end of this week or early next week if they're going to be changing that requirement. And so we are in the midst of planning for how we're going to be accommodating the public in our public spaces, and trying to move as quickly as we can to develop that plan. What we're looking at, I think initially, as we reopen, is to have appointment only meetings at the counter. They can be in person or they can be virtual. So that's probably how we'll start to ease into the reopening. We're also talking about the transitioning of the public hearing bodies. We aren't certain if the Brown Act relief that was provided by the governor for the pandemic is going to be lifted on the 15th. In fact, it may be extended for some period of time to allow public agencies to transition a little more smoothly than we had to transition to virtual meetings. So I'll keep you posted just on what the schedule will look like for transitioning to in-person hearings. We also are doing some work with other agencies on requesting some provisions in the Brown Act that would allow members of a body like the Planning Commission or BAR, some of the members to be remote at different times without having to post their address. The state is proposing a change to I think it's called the Bagley-Keene Act, that would allow for something like that for state boards and commissions. And so we're interested in pursuing something like that for the Brown Act and have been working on it. So I'll keep you posted on that as well. It'll give the appointed bodies a little bit more flexibility in terms of attendance at hearings. Any questions on that?
I would just add, that's really great if you can get that to happen where part of the body can go remotely. It'll make scheduling a lot easier for everyone as they have other things. So that's really great. I look forward to seeing that progress.
I'll let you know. Yeah.
Mr. Chair, I had one question about that. Director Plowman, did you say remote testimony or remote participation without the address being posted, or did you just mean having to be in a room?
What I said was right now, the way the Brown Act is written, if one of the planning commissioners, let's say it was you, couldn't attend in person for some reason, but wanted to participate remotely, we would have to post the address of your location and make it available for a member of the public to attend there.
Mm.
And so what we would like is to not have to post the address of your location, but allow you to attend remotely with and participate without having members of the public attend. And I think there's lots of bills swirling around regarding the Brown Act about allowing people to testify remotely for the public, which I think is a good thing too, because I think it makes the process more accessible to the public so they don't have to come to the hearing room. They can either stay home or, monitor via a computer, rather than some people have to drive an hour, to maybe come and speak in person. So there's lots of, I think, support for maintaining that component of it. We just want this other piece so we have a little more flexibility. We don't have the problem as much with the commission, but some of the other hearing bodies that we have, where we have multiple members, sometimes we have attendance issues. Sometimes there are, people that could attend remotely but can't in person because of health issues. So we're hoping we can get some traction on that. It's hard to tell whether we will or not at this point. But Ventura County's interested in it, and LA County's interested in it, and we're working with our lobbyist and CSAC.
That's great.
Yeah. Thank you.
I also wanted to let you know that we did get the results from the Busy Bee court case, and the county has prevailed. Judge Anderle ruled in the county's favor and upheld our approval. And essentially, he determined that our analysis using the PEIR, quote unquote, the county conducted a legally sufficient site-specific review of the project so that our PEIR held up in our process with the checklist. He also indicated that the county's approval of the land use permit cured any alleged violation of expansion of the non-conforming use. So I think it was a meaningful victory for the county in that regard. And I don't know how that will impact the other suits that are similar in nature, but I think Judge Anderle's decision is sort of sets a tone for how the courts will be viewing our review of these projects. In terms of board actions, the board on the 18th reviewed the ADU and JADU ordinance amendments and approved them. So that's going to be moved. We'll be submitting that to HCD. They review it and make a determination that we have adhered to the state law. So I'll keep you posted if there are any issues that come out from the HCD review. Future items, the board is going to be hearing the first reading of that emergency housing code that will be the appendix to the building code on June 15th. And we talked a little bit about that when you reviewed the 65402 for the pallet housing in Lompoc. They'll be hearing an item on the utility grade solar on the 13th of July, which is essentially for us to go back and make sure that the scope of the program is appropriate and is responsive to what the board's desires are before we start work on an environmental document for that ordinance amendment package. The Suarez cannabis case, Orange Coast, is it Orange Coast? I'm forgetting the name. I'm not sure if I have that name correct, but the Suarez appeal out in Cuyama is tentatively going to be heard by the board on the 13th of July, although we're hopeful. There seems to be some effort to resolve that prior to the 13th. We also have, I'm sorry, I skipped over SF Farms appeal, the Melville appeal. That's going to be heard by the board on the 22nd of June. And we have the 3 other appeals, Canarios, Autumn Brands, and Central Coast Ag land use permit that will be heard in August and September, and possibly Central Coast might go a little later, late September, early October. And I think that concludes my report today. I'm happy to answer any questions.
Okay, any questions of Director Planinng? Commissioner Blau?
Yeah, I just want to comment that I'm hoping successful in allowing us to participate remotely, especially for me. When I spent the last 7 days in ICU at the hospital, if I had to go to Santa Barbara today, I couldn't be there. I mean, when you're 7 days laying in bed and basically bleeding to death, it's kind of difficult to, get healthy again right away. So I hope that happens. That's just what
Yeah, Mr. Chair, Commissioner Blau, I have you in mind specifically when I was thinking about it as well. And I'm sorry to hear about your health.
Well, I'm good now.
Good.
So, almost, yeah. It's my wife.
You look pretty good.
Well, I will tell you what, they put in 9 pints of blood.
Oh,
well, you know what? You only have 10 and a half to start with. So I guess I was a little anemic. So
You're a little low.
A little low.
Good to see you, Dan. Okay, all right. Well, no more questions. We'll move on then to the standard agenda. And I don't know, Commissioner Blau, you want to go ahead and make a motion on?
I'm Chair Freeney, if I could interject again, sorry. I had too much energy drinks today, so
Okay.
I'm vibrating. I recommend that we if we want to take the continuance first, we read it into the record. Have any questions of staff, do public comment just on the continuance, and then ask for a motion just on the continuance.
And Larry, that was my suggestion. Now, you're the chair. You get to decide which item goes first, second, third. It makes no difference what the staff published. I mean, when we walk in the meeting, there's items number 4, and you, in your own discretion, decide it's number 1, your discretion. So I agree with Secretary Wilson. Just take item 3, have David read it in there, ask for public testimony, close the public hearing, then we can make the motion for the continuance. That's just my suggestion. Mr. Wilson is an expert, so he can weigh in and tell us what to do.
Okay, very good. So I guess what we would like to do then is move item 3 up to the first item. And is staff available to present?
Well, again, I don't think you need a staff report. You just need to read it in the record and then ask for public comment and then make the motion for continuance, or maybe you make the motion first and then ask for staff. I'm just saying, let Mr. Wilson guide us. I think he's the expert. I just want to get people, I don't want people sitting here for 3 or 4 hours doing nothing and then go home. It just, to me, that just is not, it's not friendly for us to the public.
No, I agree with you. I'm just a little lost here on how to get it done. So I want to make sure I didn't know if you needed staff to say, yes, there is the continuance request. So Mr. Wilson.
Mr. Chair, Commissioners, thank you. My recommendation is, as you indicated, Chair, we'll move item 3 to item number 1. Mr. Villalobos will read it in the record. Staff is available to just provide insight on the contingency request. Then you can ask for public comment and then bring it back to the commission for a motion on the continuance. And just, I would encourage the public that on this item, on this particular action, if it's just on the continuance, to focus their comments on the continuance request. And then we can bring it back to the commission for a vote. So I think Mr. Villalobos is ready to read it in the record, if that would be what you'd like, Chair.
Okay, thank you. And thank you everyone for your patience as I bumble along through this. Okay, Mr. Villalobos, would you please read item 3 into the record?
Yes, thank you, Mr. Chair. The following is a hearing on the request of Mark Chatillo on behalf of the Santa Barbara Coalition for Responsible Cannabis, appellant to consider case number 21APL5, an appeal of approval of coastal development permit case number 19 CDP 62 by the Director of the Planning and Development Department.
Thank you, Mr. Villalobos. Back to you, Mr. Wilson. Do we go ahead and just go down the whole order of evidence sheet, ask for planning commissioners, run the whole gig?
Mr. Chair, Commissioners, I recommend you do that. You ask for any ex parte on the continuance. Ms. Elkurdy is available if you have any questions on the request as far as the date that they're asking, staff's recommendation on the continuance, and then just do public comment and come back. So that'd be my recommendation.
Very good. Thank you. So planning commissioners, do you have any ex parte or site visits you'd like to declare? Commissioner Cooney.
Yes, thank you, Mr. Chair. I don't have much to report. I did not talk to the applicant or the appellant. However, I made a couple of trips by this site to orient vis-a-vis the other sites in the immediate vicinity.
Okay, thank you, Commissioner Cooney. Okay, Ms. Elkurdy, we're ready for you. And we're not hearing you.
Oh, you're not hearing me?
There, that's better.
Okay. Good morning, Chair Farini and members of
Good
the
morning.
commission. So as you know, Planning and Development received a joint request from the applicant and the appellant to continue the appeal of the Creek Property Cannabis Cultivation Project to June 30th. It's my understanding that they're working together to develop revisions to certain project documents, which might satisfy the appellant's concerns, and they'd like the additional time to facilitate these discussions.
Okay, thank you. And did they have a date? I'm sorry.
Yes, Chair, the date requested is June 30th.
June 30th. Okay. And okay, thank you for that. Mr. Chatillo. Good morning.
Good morning. Good morning, Mr. Chair and members of the commission. First, Commissioner Blau, I think we're all relieved to hear that you're back in the saddle, and glad that you're looking and feeling better. And thank you for the suggestion of adopting a practice at the PC of taking these continuance requests first. As a frequent flyer, I appreciate that. I think that that will help facilitate, all of our days and process. Speaking to the merits of the request, we have been working cooperatively with the applicants here, and we're very close, but not quite there. So we were working very hard to try and have this wrapped up in advance for this hearing, and provide staff with the opportunity, sufficient time to review everything, so that it would be a much simpler process for your commission's review. We didn't quite make it, and working with staff, we did select the 30th as being an appropriate continuance date. I don't think that the applicant, I don't see them on the attendance list, but I did text them a few moments ago to let them know that this was coming up early. And I know that they fully support this request. So thanks for considering it and for the change to the process. We do very much support it and would ask that you do approve the continuance. Thanks.
Thank you, Mr. Totillo. And now we'll go on to public comment. Is there anyone from the public who would like to comment on the moving of the meeting?
Mr. Chair, we have one, possibly three. There's two members that I need to check to see what item they want to comment on. Our first speaker is Renee O'Neill.
Good morning. First, I would like to just let Commissioner Blau know that, can you hear me? I'm sorry, I didn't check.
We can hear you this time. Yes.
Okay, thank you. Sorry about the confusion. Commissioner Blau, my heart, my prayers go out to you. I did not know you were in such dire straits there for a while, and I just want to say God bless you. Regarding the continuance, I'm happy, Commissioner Blau, to hear your suggestions. I think this has been confusing for so many people, and I appreciate knowing a heads up. In fact, I was going to also shoot out an email to our greater community groups that we're planning to speak to this today, to let them know. And Mark, if you have done that, then I won't double track you, but I will send out a shout out to the concerned CARP group and other folks. So anyways, I will be talking to you during the other cannabis hearing, apparently, at New Era. Have a good morning.
Thank you, Ms. O'Neill.
Mr. Chair, our next speaker possibly is Louis Shaw. Louis, I'm not quite sure which item you were wanting to speak on. If you could clarify that for the record, I would appreciate it.
Able to hear me?
We can hear you.
Oh, okay, good. I was actually going to be speaking on the Ron and Chew.
I'm sorry, which project?
On the Ron and Chew. I'm not sure what that number would be. Moment, please.
What's, Mr. Lewis, what was the address or what was the location of the item that you're interested in? I'm not quite sure, based on your description, which one you're referring to.
I'm actually unable to get to it while I'm on this particular screen. I believe it was like item 4. Or...
The New Era project on Sabata Canyon?
Yes, I believe.
Okay. Okay, we'll get to that later today. I just want to make sure that you didn't want to speak on this item. Thank you for clarifying that for us. I appreciate it.
Yes, sir. Yes, sir. Absolutely. And thank you for hearing me.
All right, Mr. Chair. We also have 2 call-in speakers. I suspect they're for item number 2, but I just want to give them the opportunity if they wanted to speak on the continuance for item number 3. So if you are joining us by phone, if you could just unmute yourself by hitting *6 on your phone, just to clarify which item you're here to speak on, I would appreciate it. Call-in user 1. Yeah, can you clarify which item that you are here to speak on?
Yes, I'm here to speak on the New Era project.
Okay, great. Thank you so much. We'll get to that later today. And our next speaker, if your phone number ends with 232, if you can just clarify which item you were here to speak on.
The homestay permit on Figueroa Mountain Road.
Okay, we'll get to that later this morning. Thank you for clarifying. I appreciate that.
Sure.
All right. With that, Mr. Chair, I think that we're done. We're through our public speakers for this item.
Okay, very good. Thank you, Mr. Villalobos. And I don't think anyone has anything to add, Mr. Chitillo or staff. We're all good to go. Okay, Planning Commission questions.
Now that I'm here.
Good to see you, Commissioner Park. Commissioner Cooney.
I'm ready to make a motion regarding the request for continuance. If now's not appropriate, I'll wait.
Please do, Commissioner Cooney.
So my motion would be to grant the continuance request, moving the matter from today to June 30.
Great.
I'll
Thank
second
you.
it.
Thank you, Commissioner Blau. Mr. Villalobos?
Commissioner Cooney.
Aye.
Commissioner Bradley.
Aye.
Commissioner Park.
You know, I better abstain because I don't even know what we're talking about.
Fair enough. Commissioner Blau.
Aye.
Chair Farini.
Aye.
Motion passes 401.
Very good. Okay, now on to item 1 of the standard agenda. Mr. Villalobos, could you please read that into the record?
Yes, thank you, Mr. Chair. The following is a hearing on the request of Ernie Mancy, SB Clark, LLC, property owner, to consider case number 13 GPA 5, 13 RZN 1, 13 TRM 1, 13 DVP 10, 17 RDN 5, 20 GOV 3, and to recommend that the Board of Supervisors certify the subsequent environmental impact report 14 EIR 7 with SEIR revision letter dated July 20th pursuant to state guidelines for implementation of the California Environmental Quality Act.
Okay, thank you, Mr. Villalobos. And on to Planning Commissioner's ex parte or site visits to declare. Okay, not seeing any, then we'll move on to staff presentation.
Good morning, Chair Farini, members of the commission. Shannon Reese here, and this project was last before your commission on April 7th of this year. It was continued for staff to prepare findings for denial. And at that hearing, the commission had listed a few reasons for project denial during the motion. The first being that the project was not consistent with the surrounding area and that the proposed density is not compatible with the community. And in order to ensure the neighborhood compatibility, the commission stated that they'd like to see a larger portion of the key site developed with lower density and the designated open space reduced to accommodate housing on more of the property. The second item being that secondary access was not firmly established to support the impacts of the project, and the developer doesn't have a private maintenance agreement in place as was requested by the Planning Commission on November 4th, 2020. And additionally, that the commission had stated that the developer should utilize secondary access that wasn't along Chancellor Street. So staff prepared a memo detailing the findings for denial with revised attachments for environmental review and the resolutions there. And I have the recommendations in a slide here. So staff recommends that the commission recommend to the board that they make the required findings for denial for the case numbers that are listed here on the slide, being the general plan amendment, the rezone, the map, development plan, and the road naming. The second being recommend that the board determine that the denial of those case numbers is exempt from CEQA pursuant to guideline section 15270, and recommend that the board deny those case numbers that are listed on the slide. And also direct staff to transmit the comprehensive plan conformity report required by Government Code Section 65402A to General Services, Real Property Division, and the Board of Supervisors. And staff is available to answer any questions you may have about the memo or findings. I believe that Mr. George Amoon from County Parks may be in attendance. And Mr. Will Robertson from Public Works Transportation Division, just in case there are any last minute questions about the open space or traffic. We also have the applicant, Mr. Matt Mancy, here, and he also submitted a comment letter that was distributed to the commission yesterday afternoon.
Okay, thank you, Ms. Reese. Any questions of staff from commissioners? Okay, not seeing any. We'll move on to the applicant, Mr. Manzi.
Good morning. Can you guys hear me?
Good morning. Yes, we can hear you.
Morning. Thank you for having me, members of the Planning Commission. I just wanted to respond to the findings for denial. I did submit the letter, but we don't believe these findings are valid. We believe that staff was just asked to kind of invent these because there wasn't really a real legal reason for the project to be denied. We've complied with everything that we've been asked. The Orchid Community Plan it's consistent with what we've put together. And we've gone over and above to create a viable project based on that Orchid Community Plan. And so there aren't really any real reasons for denial here. I'll just quickly go through the 2 points here. Saying that the project is not consistent with the surrounding area. The surrounding area is a mobile home park that's high density. So the optics there are confusing. Are we supposed to build mobile homes to be consistent with the area? It just doesn't quite make sense. When we submitted this project originally, we had a lower density project that was taking over most of the site. There was not much open space dedication. And we were told that we should not do that, that we should dedicate more open space. So the project that you have here is based on those comments, almost 16 years ago. And then in regards to the finding for denial on the easement issue, we have the legal easement. The traffic report states that the road does support the traffic that would go through there, which would be about 10% of the project. And regards to the easement being overburdened, I'm just going to read a statement from our attorney on that because I'm not a lawyer. There's no merit to the suggestion that the proposed use of Chancellor Street will overburden the easement. An easement is overburdened when the easement holder engages in a type of manner of use that was not originally contemplated by parties, i.e. using a non-exclusive access easement as a parking lot, thereby blocking passage and completely prohibiting the use of the easement for access purposes. The broad language in the original grant of the Chancellor Street easement demonstrates that the proposed use of the easement for secondary emergency access is exactly what was contemplated by the parties and therefore would not overburden the easement. And then just to speak to the private maintenance agreement that we were asked to come up with, we tried in good faith, and we can't force neighbors to enter into a private agreement. But luckily, there's a civil code section that addresses that if you don't have an agreement between the two parties. The civil code section 845 governs the maintenance obligations for right-of-ways of private roads. Subsection B notes that the absent of an agreement among multiple owners of an easement as to an apportionment of the cost of maintenance, the cost shall be shared proportionately to the use made of the easement by each owner. So there is guidance for that in the absence of a maintenance agreement, but that's just kind of been ignored. So just in summary, just humbly ask that the commission reconsider denying this project and look at it objectively, and it's going to be providing badly needed housing for the state and for the county and for our community. So thank you very much.
Thank you, Mr. Manzi. Commissioner Park.
I just had a quick question of Mr. Mancy, still there. Mr. Mansi, I thought I heard you refer to something 16 years ago, and I didn't quite catch what the reference was. Could you explain what you were talking about?
Yes, Commissioner Park, members of the commission, this project that's before you today was a new iteration of an original submittal back in 2004. In that submittal, we had units sprawled over the entire acreage of the site, including the lower mesa where we had ranchettes that were about half-acre ranchettes. And feedback from the Planning Commission and ultimately the Board of Supervisors was that they did not want that and that they wanted more open space dedication and that they wanted more of the units put on the upper mesa. And so the project that's before you today is a result of that feedback and that denial ultimately.
Great. Thanks.
Commissioner Blau. And unmute, Dan.
Not sure this is a question for Mr. Mansi or just a comment, but I certainly understand the frustration of dealing with a project over a 15, 16-year time frame. I'm quite certain that 15, 16 years ago, that was the, hang on a minute. That was the desire for more open space, more clustering. Not so sure now. And although he might have legally addressed the issues that were addressed over the last 16 years, for me, what comes here today is the project doesn't work. It needs to be redesigned. I'm sorry that he's taking comments from 16 years ago going forward, whether it was the board, the staff, the commissions. This one just doesn't work. There's a good project to be had there, and I'd love to see him redesign one. And I would ignore the comments for 15, 16 years ago. Look at it in light of today. Bring us a project that makes sense for today. Those are my. That's not really a question, but like an apology to Mr. Mansi.
Thank you, Commissioner Blau. Okay. Does staff have anything else to add?
Mr. Chair, no, staff doesn't have any further comments at this time.
Okay. And do we have public testimony, Mr. Villalobos?
Mr. Chair, we do have one public comment. That's Mr. Hassett. If anyone else wants to speak on the item that's in the meeting, just raise your hand and I'll call on you. So our first speaker will be David Hassett.
Hi. Can you guys hear me okay?
I hear you. Yes.
Thank you for letting me speak. This has been an ongoing project, but it's also zoned for 10-acre ranchettes. So I do want to state that we should move forward on stopping this project moving forward because it doesn't fit for traffic issues, a lot of other issues that's been pointed out over the years. So I do agree with moving forward on the denial. Thank you.
Thank you.
And Mr. Chair, I didn't see any other hands raised for this item. I think Ms. O'Neill has had her hand raised but I think that she's preemptively done that for the next item.
Okay, very good. All right, well, with that, then we'll close the public comment portion of this.
Again.
No, I think that's bullshit.
I know.
Oh, okay.
Okay.
So we'll do that, and then does the applicant have anything they'd like to add?
Members of the commission, I do not.
Okay, thank you, Mr. Manzi. Okay, and then on to Planning Commission, do we have any questions or should we go right into the comments and deliberations? Not seeing any questions. We'll go to comments and deliberations. I would echo what Commissioner Bao said. Times have changed. A high density project right there and the impacts it will have on the Chancellor Road residents doesn't seem appropriate. It does seem like that definitely gives me pause to approve a zoning change to go to such a high density from what right now is a very low density. I hope to see a project there that fits the community and is good for the builder as well. Anyone else? Okay, I'll go ahead and make a motion to approve staff's recommendations 2.0 on the from the staff report dated May 18th. Commissioner Park.
I'll second the motion, and I wanted to add, just by way of comment, that I appreciate the comment that Commissioner Blau made and that you made as well, Chair Farini, but I also think that this second part of the findings is very important as well, and that is there really secondary access or not? And I don't really think it's been secured. I understand this whole issue of overburdening of easements. I kind of see it a little bit differently than the developer's attorney. I think intensity of use is important in those cases. And I'm just really not satisfied that very important part of the project has been adequately addressed. So and that's one reason I support the motion then.
Thank you, Commissioner Park. Commissioner Blau?
Sorry, I was going to make the second, so let Mr. Park do it. That's great.
Okay. Okay, Mr. Villalobos, on the roll call.
Commissioner Cooney.
Aye.
Commissioner Bradley.
No?
Commissioner Park.
Aye.
Commissioner Blau.
Aye.
Chair Farini.
Aye.
Motion passes 4-1.
Okay, thank you. All right, Mr. Villalobos, let's go ahead and read item 2 into the record.
Thank you, Mr. Chair. The following is a hearing on the request of Kelly Rose to consider case number 20 APL 35, an appeal of the planning director's approval of case number 20 HOM 17.
Okay, thank you, Mr. Villalobos. And we have a staff report ready to go.
Morning, Mr. Chair and Commissioners. My name is Tina Mitchell. And I believe Mr. Seawards has the PowerPoint.
Ex-party contacts.
Oh, thank you, Commissioner Park. Yeah, ex parte. Commissioner Park.
Yes, and I spoke yesterday over the telephone with Mr. Kelly Rose.
Okay, very good. And I spoke with Mr. Rose on Monday as well. Thank you, Commissioner Park. Okay, now on to staff report.
Okay. Thank you, Mr. Chair and Commissioners. The case before you today is a request by Mr. Kelly Rose to consider an appeal of the Trabuco Homestay Land Use Permit, which approved the use of a 2-bedroom single-family dwelling as a homestay in the San Ynez area. Next slide, please. As shown on the vicinity map before you, the project site is located off Figueroa Mountain Road and is approximately a half-mile north of Highway 154 in Los Olivos. Surrounding uses are primarily agricultural and residential. This area is zoned Ag 110, and homestays are an allowed use in the Ag 1 zone district with a land use permit and conformance to the LUDC development standards. Next slide, please. Existing structures on this 6-acre property include a single-family dwelling, a swimming pool, a detached garage, which contains a pool cabana, and an accessory dwelling unit. For reference, this ADU, or the ADU, was originally permitted as a guest house, but was converted to an ADU in 2018. The single-family dwelling contains 2 bedrooms and is the proposed location of the homestay. Next slide, please. The subject property has been operating a homestay within the single-family dwelling since 2012. When the homestay ordinance went into effect on October 1st, 2018, the property owner submitted an application for a homestay permit. This initial homestay permit was valid from April 2019 to April 2020. The property owner submitted an application to renew the homestay permit on March 31st, 2020. During the processing of this permit, staff determined that there was an unpermitted living unit within the detached garage. The property owner cooperated with staff to obtain a land use permit to legalize the unpermitted living unit as a pool cabana. The homestay permit was then approved on October 29th, 2020, based on the application's conformance with the LUDC and homestay development standards. A timely appeal was subsequently filed by Kelly Rose. Next slide, please. The appellant cited the following 4 issues as the basis of this appeal. First, the appellant asserts that between 2015 and 2020, the applicant simultaneously rented out the single-family dwelling, the ADU, as well as the unpermitted living unit in the garage. Second, the appellant asserts that the applicant operated the homestay, including within the ADU and the unpermitted living unit, outside of the time frame allowed by his previous homestay permit. Third, the appellant asserts that the applicant did not reside on the property since the ADU was being rented out on a short-term basis simultaneously with the single-family dwelling and the unpermitted living unit. And lastly, the appellant expressed concern that no fines, penalties, or collection of unpaid transient occupancy tax would be imposed on the property owner for the violations as described. Next slide, please. In response, staff can confirm that the ADU and the unpermitted living unit were previously being rented out on a short-term basis along with the single-family dwelling. But the applicant took corrective action by receiving a land use permit to convert the unpermitted living unit into a pool cabana and by ceasing all short-term rental operation within the ADU prior to our approval of the subject homestay permit. Staff has advised the applicant that homestay rentals are only permitted within the single-family dwelling. The ADU may not be rented out on a short-term basis, and the cabana is not permitted to be rented. As previously mentioned, the property owner submitted a homestay permit application in a timely manner when the homestay ordinance was adopted in 2018. When the property owner submitted the subject renewal homestay application, he cooperated with staff to take corrective action regarding the unpermitted living unit and by ceasing short-term rental of the ADU. So P&D did not initiate any formal enforcement action. The property owner has confirmed to staff's satisfaction that he is currently inhabiting the ADU on site and has ceased short-term rental of the ADU. The property owner submitted 2 acceptable forms of proof of on-site residency. A condition of approval requiring owner or long-term tenant residency has been applied to this permit. As discussed in the staff report, a review of P&D records found that no formal complaints have been filed for this property prior to the appellant contacting staff during our review of the subject homestay permit. As mentioned before, P&D did not initiate any formal enforcement action against the property owner during this time period because the applicant was voluntarily complying with staff directions to take corrective action. Since there are no open violation cases and the applicant resolved all violations recognized by P&D during the permitting process, no fines have been assessed against this property. Outside of notices of violation, the LUDC does not provide a process for assessing fines or penalties for zoning compliance issues. In response to the appellant's concern regarding unpaid TOT, Planning and Development does not enforce Chapter 32 taxation. Provided the LUP for the homestay is issued and the applicant continues operating the homestay, the County of Santa Barbara Tax Collector's Office will determine the TOT amount due and require that the applicant pay the TOT. Next slide, please. This project can be found exempt from CEQA because CEQA Guidelines Section 15301 applies. This section covers the operation, permitting, and leasing of existing private structures involving no expansion of use. Next slide, please. In conclusion, staff recommends that the commission deny the appeal, case number 20 APL-35, make the required findings for approval for case number 20 HOM 17, determine that the project is exempt from CEQA, and grant de novo approval of the project subject to the conditions set forth in attachment B of the staff report. This concludes staff's presentation, and we are available for any questions that you have.
Okay, Commissioner Park.
Yeah, I have a question. I think I can pretty well remember all of our homestay appeals. And I can't remember one where this issue has come up before of should there be a fine or payment for TOT taxes that weren't paid while a homestay is being put in conforming or legal form like this one. Have we run into that before?
Commissioner Park, through the chair, I did review some of our previous homestay appeals as well in preparation, and I couldn't find this issue come up. That I didn't see that this issue has come up before. Generally, our response is that we don't enforce Chapter 32. To expand on the issue, though, I did consult with the tax collector's office regarding the applicant's record of TOT payment, and they did confirm that the applicant has remitted TOT to the county from March 2012 to the present. They said there was one break from October 2018 to March 2019, and that was presumably when they were applying and receiving a homestay permit.
Okay, thank you.
Commissioner Bradley.
I think I'm unmuted. I had a couple of questions in the staff report, Ms. Alcurdy, on the project description. There's an explanation that the maximum homestay would be 4 occupants, but in some of the supporting documentation, the VRBO says 6. So I don't know if that is flexible, or is it better to write this for 6 or 4? I don't know. I know VRBO is imperfect in terms of getting the project descriptions right. So I guess I just want to see that consistent because there's probably going to be enforcement requests if this is issued. And secondly, the question about, hold on a second. I don't know that I saw a site plan in the staff report. There was a floor plan of the house attached to the permit, and yet there's a condition number 8 that talks about noise at a property line. And I guess I'm struggling. Where somewhere in the packet, or how does that work when you're trying to enforce conditions about, noise at a property line, and we only see a picture of the floor plan of the house? Where is that? Never mind the ADU and the cabana and all that stuff. Is that in your file?
I don't believe, Commissioner Bradley, through the chair, I don't believe we have a full site plan in our file. I do have the aerial image that kind of shows the property lines that was in the PowerPoint. So that gives you an idea of where the structure is. Could you go back to that and just pop that up on the screen? Because I actually had a hard time finding the site on Google Maps. It kind of just gave me a blank space. So could you Yeah, Mr. Seawards, can you
Yep.
pull up
It does.
slide 3, I believe?
Yeah, the slide's up on the screen. And Ms. Mitchell, if you could clarify, it's the homestay is going to be located in an existing single-family dwelling that's been previously permitted. Is that accurate?
Yeah, that's accurate, Mr. Seawards. And we would have a site plan on file for the LUP that permitted that single family dwelling.
And
But
there's
the
no
LUP
changes there's no changes with this homestay to the structure. Is that correct?
That's correct.
Okay, but I mean, in issuing the homestay permit, which you actually already issued because this is an appeal, there wasn't a site plan as part of the homestay permit issuance that shows where these buildings are in relation to neighbors or anything? Because I mean, we're looking at this picture, it gives me a much better idea about, you know, the intensity of use on the single family dwelling location where the homestay is going to be.
Hi, Commissioner Bradley. Yeah, it appears that we just have a floor plan that is half hand-drawn and half some, I think the floor plan that's been attachment F is all that staff has at this time.
Well, I mean, even the aerial photo from your slide would be good to have attached to the permit. I think this is going to be a compliance issue moving forward. But anyway, thank you for putting that up there. And then, so the question was, did the applicant ever have to do notice to property owners for not renting out the ADU, or is that an old document that we don't use anymore? It used to be kind of standard practice when you had a guest house, you couldn't rent it out. It was only intended to be for owners. So I don't know if that was any kind of recorded document from a previous permitting.
Commissioner Bradley, through the chair, there is not a requirement for a notice to property owner for ADUs. There is a notice to property owner requirement for the cabana. So when we went through the permitting for that, a notice to property owner was recorded for the cabana.
Okay, those were all my questions. Thank you.
Commissioner Blau.
Yeah, I'm going to reserve my questions until after public comment.
Okay, very good. Okay, we'll move on then to the, I guess, the appellant. Is that Mr. Rose?
Yes, I'm here.
Okay, are you ready to go?
I am ready to go. Thank you. Good morning. My name's Kelly Rose, and I live in Los Olivos. And I'm here, as you know, to appeal the land use permit for a homestay. What I'm asking is for the Planning Commission to either revoke or issue a stay regarding this permit until such time as the property owner addresses the violations relative to the property, which are ongoing, the most egregious of which was operating an illegal short-term rental and homestay for 9 years without paying any transient occupancy tax. And I'd like to start by just a philosophical statement on enforcement of rules. When people are allowed to break the rules without consequences, you create an environment where people believe they are better off asking for forgiveness than asking for permission. And that is exactly the nature of the case that is before you today. My appeal is based on a situation where a property owner repeatedly violated the LUDC over a period of 9 years, and not out of ignorance, but out of economic interest. These weren't just innocent mistakes. We're not talking about a Joe handyman who just thinks it's okay to convert his garage into a man cave without a permit. I mean, who needs a permit to work on their own house? In this case, we're talking about a property owner who is a longtime builder of high-end residences. His website states that since 1994, he has been building stunning mansion-style homes and luxury ranches in Montecito, Hope Ranch, Santa Barbara, and in the San Ynez Valley. He knows the rules and he purposely violated them for personal economic gain while depriving the county of significant transient occupancy tax. And I contend that planning and development fostered this behavior by ignoring complaints, and when forced to acknowledge them, simply forgave the violations. It apparently is that within planning and development, that resolving violations through proper permits is considered an amnestying process. That's what planning and development wrote specifically to this matter. It also said that planning and development isn't responsible for collecting TOT. Apparently, within planning and development, forgiveness is free and absolute. There are no consequences, and if you're caught, it doesn't matter because all is forgiven. I wrote a letter accompanying the appeal dated November 3rd, and I listed all the specific violations and the code references to the LUDC. I'm not going to go through all that, but I am going to give you some highlights. First, the use of a guest house and an accessory dwelling unit as a short-term rental and homestay are both illegal. They're both prohibited from being used as homestays. In 2007, Mr. Trabucco got a permit to build an detached guest house. After final inspection, he installed a kitchen, full kitchen. Kitchens are not allowed within guest houses. Starting in 2012, Mr. Trabucco started renting out the guest house on weekends as a short-term rental. He listed it on Airbnb and VRBO and all the other websites as a 2-bedroom, 2-bath house with a full kitchen. It was rented almost every weekend, especially in that 12-year period, especially during the periods between April and December. As confirmed by the county tax collector treasurer, this structure did not have a transient occupancy tax, and no TOT tax was ever paid on this guest house. Guest houses can't be rented, so they can't have a TOT. In 2018, Mr. Trabucco got a permit and changed the designation of a guest house to an accessory dwelling unit. This resolved the problem of the unpermitted illegal kitchen. However, Mr. Trabucco continued to rent it out as a homestay, just like he did when it was a guest house. The rules for an ADU say they can't be rented out for less than 30 days. So again, just ignore the rules. This situation continued from October 2018 until November 2020, even after the new homestay permit was approved by planning and development. Nothing changed. Just like the rental for the guest house, the rental of the ADU is illegal, and just like the guest house, no TOT certificate was ever obtained and no TOT was ever paid. And these facts are not disputed by planning and development. The second issue is the creation of a illegal, unpermitted cottage, which was rented out as part of the primary residence during a period between 2012 and 2020. What happened was that Mr. Trabucco obtained a permit to create a combined detached garage and a detached workshop. What ended up happening was part of that structure was carved out and created as a cottage, 1-bedroom, 1-bath cottage that got added to the main residence. And to address Commissioner Bridley's comment, the reason it became a 3-bedroom, 3-bath rental on all the websites was that illegal, unpermitted cottage was just integrated into the main house for rental purposes. So this was done from 2012 up to 2018. And then when the homestay rules came into effect, he just continued to, and the homestay permit was for a 3-bedroom, 3-bath house. Again, incorporating an illegal structure into that. Now, of course, because both of those structures were rented simultaneously, another violation occurred because Mr. Trabucco couldn't be on the property when all the buildings on the property that were residences were being occupied. Now, planning and development doesn't dispute that fact either. These are all undisputed facts. Now, the staff summarized the entire situation as everything is good and everything is fine. Now, for example, the comment was made, Planning and Development contacted the tax collector's office and found out that there was a TOT. Sure, there was a TOT on the primary residence, never a TOT on the guest house / ADU. Now, that wasn't in the staff report. Now, all the staff had to do was to ask the county tax collector, is there a separate TOT, which is required for every short-term rental? Is there a separate TOT for the guest house and the ADU? And the answer would have been no. 9 years of rental, no TOT certificate, no TOT payment. I've detailed a situation here where the property owner knowingly and purposely violated provisions within the LUDC over a 9-year period of time by building unpermitted illegal structures, renting them out as short-term rentals, and operating these without proper TOT certificates and not paying TOT on the rental income, depriving the county of revenue, and then receiving total amnesty for those actions. I did a quick calculation. I'm a CPA. I know how to count. I did a quick calculation and determined that at a minimum, there's over $25,000 of unpaid TOT on the guest house and the ADU. It probably is closer to 50,000. To me, that's a meaningful number. I can't find any support in the LUDC code that says why unpaid TOT is a thing that you can just simply ignore. If there were noise coming out of there, if there were too many people there, those would all be violations that the Planning and Development Department would recognize. These would be problems. Non-payment of TOT and illegal use of a dwelling apparently is not a problem. I'm asking the Planning Commission to revoke or suspend the current homestay land use permit as approved by the Planning and Development until Mr. Trabucco pays the full amount of the unpaid TOT associated with the unreported rental income on the guest house and ADU. Just like a driver's license, operating a homestay is a privilege. It's not a right. And this privilege should require that you comply with the rules. There should be consequences for willful violations of the LUDC that result in a loss of substantial revenue to the county. Forgiveness is fine, but it should be preceded by restitution. Equity, fairness, common sense, and responsibility to those who follow the rule demand that the property owner pay TOT before they are allowed to continue their homestay rental business. Thank you for your time and consideration.
Thank you, Mr. Rose. Planning Commissioner's questions of Mr. Rose. Commissioner Blau?
Yeah, my first question is, Mr. Rose, do you know what percentage of his rental on the properties were more than 30 days and those that were less than 30 days?
The rentals to answer your question, Commissioner Blau, the rentals on the property were all less than 30 days. They were all weekends. And I know that personally because I ride my horse right beside that property at least twice a week. And I know who is there during the week and who is there on the weekend. And the weekend residents were always different every single weekend.
Great, thank you. And I will point out to you, I really sympathize with your concerns and appreciate your fact that the county's not being paid. Although I need to tell you that when the county board of supervisors on a 3-2 vote decided to do away with rental income or short-term rental income, at that point in time, the county was collecting about $1.6 million in TOT taxes for the short-term rentals, and by the treasurer's, excuse me, by Mr. Hagan's estimation, that was about 1/3 of the taxes that were due the county. There is probably 1/3 of the people that are paying them voluntarily, 1/3 that don't pay them on purpose, 1/3 don't know that they should be paying them. But the county board, in their wisdom, decided to give up $4 or $5 million in revenue and do short-term rentals. So, I'm going to have to ask staff. This is where my question comes in later on. When were they obligated to stop the short-term rentals with an ordinance? And prior to that, there was no prohibition against it. Your thoughts, Mr. Rose?
Well, I do know that when we talked, and again, back to the fact that there were supposedly no complaints, when we made comments back in 2012, 2013, 2014 about this business, we were told by planning there are no rules. We don't really have rules around short-term rentals. Now, that changed in 2017 when the Board of Supervisors passed the resolution on homestays and created rules. That provision went into effect in October of 2018. So from 2018, October 2018 forward, there were specific rules for homestays that if you didn't have a permit, you then were operating illegal and could be stopped.
Yeah, and I agree with you, although there was it's kind of like interesting, we say as a county, okay, today there's a permit required. Well, this county can sometimes take 1.5 years to get a permit issued. So that's kind of a bad issue. But I do need to point out to you, as I think that the staff did in their staff report, we have absolutely zero control of Mr. Hagan. It's up to him entirely to decide how he enforces property tax enforcement, revenue, and I don't believe we have the authority to pull the permit or to deny a permit based on unpaid property taxes, because we're not in the position to determine whether the amount was due or not. It's up to Mr. Hagan in his sole authority. But that's a question for staff. If I'm wrong about that, I need to know that going forward to make a decision.
Commissioner Bradley.
Yeah, I just kind of related to that. So your letter, Mr. Rose, has a statement that says you'd be okay with a land use permit being issued for this if the restitution is made. And I know you've made that eloquently in your testimony today. I guess what I'm wondering on with these homestays, it's often about neighborhood compatibility, I think is what we hear. And Commissioner Park can correct me, but I've only been on maybe half of them, and usually it has to do with neighborhood compatibility. So I'm not hearing from you or understanding how has it been to live next to this property? I mean, that's kind of the issue as a planning commission that maybe we get to grapple with. And I didn't hear that really articulated. I appreciate, though, your listing of all, kind of the moving parts and how it's been, engineered repeatedly over to try to address rules or not address rules. So just interested in your feedback about living next door, if that's where you are.
Well, yes, Commissioner Bradley, again, I just wanted to get back to the reason I don't have a concern or don't have a complaint or am not arguing about the issuance of the homestay permit for the primary residence, because that is allowed. What I am saying is what really upset all of us was that for a 9-year period of time, a structure that is not legal to be rented out for less than 30 days was rented out. And despite a number of complaints about the fact that now we have 2 homestays on one property that is absolutely against the Land Use and Development Code, that was just simply forgiven. Now, one homestay on a property is problematic from noise, from traffic, and all that. 2 of them are doubly problematic. So yes, I mean, the staff says there were no complaints. Well, I guess letters to planning and development and calls to the police on noise levels, isn't a complaint, but that's the best we can do. I mean, we as neighbors are not the police, and nor should we be. I think, we'd be responsible for policing homestays. But that's kind of a separate issue from the fact that there is no argument that for 9 years, a totally 100% use of a unpermitted structure was allowed to continue, and no revenue was ever paid on it except to the owner of the property. So, I mean, that's a little bit like stealing.
Okay, thank you.
All right.
That's all.
Okay, thank you. Is the applicant present? Do they have a presentation?
Mr. Chair, Commissioners, I'd like to ask Ms. Mitchell to go on the record indicating her conversations with the applicant about the hearing today. I'm inviting him to come. I don't see the applicant on. We have two options. One, we could proceed without the applicant. Ms. Mitchell can go on the record and indicate her conversation with the applicant, or we can take a break and try to contact the applicant to have them available for the hearing. Mr. Chair, if we could have Ms. Mitchell just go on the record, indicate her conversations.
Great. Ms. Mitchell.
Thank you, Mr. Chair. Yes, I did have a phone call with Mr. Tribuco this morning just to confirm that he was all set to attend the hearing this morning. And then I also did text him when the Key Site 3 item was ending. So he did have a couple notifications. I've also emailed him in the interim here. So we've made multiple attempts to reach out, and I'm happy to give him a call if you want to give us a break.
Okay, well, I'm sure everyone would appreciate a break at this time. So how about we take a 10-minute break and come back? Okay, thank you.
Mr. Chair, we're back on the air. During the break, we're just able to confirm Mr. Trabucco is joining us. He joined as an attendee, so I have allowed him to speak. So I'll rename him on the list, but Mr. Chair, if you could just, I'm not sure how much time we gave to Mr. Rose, just would suggest that we give the same amount of time to Mr. Trabucco.
Okay, thank you, Mr. Villalobos. Yes, Mr. Trabucco, as the applicant, you have 15 minutes for a presentation.
Okay, can everybody hear me?
We hear you well.
Okay, great. Just a little bit of background. I've been a general contractor builder at the San Bernardino County since 1981. So that's a long time, but I purchased this property in 2004. And then I believe the remodel of the existing 2-bedroom, 2.5 bath was about in 2007. I don't know, somewhere around there. And then maybe 2008, 9, somewhere the garage workshop was built. And then maybe 2010, maybe 2009. I don't know exactly the years, but I designed and built the guest house. So when we started doing the vacation rental, believe it was in 2012, the TOT tax has been paid consistently from 2012 to current. There was a time somebody mentioned that there wasn't TOT paid. I don't remember why, if that was in the maybe the applying for a homestay in 18. I'm not sure, but anyway, the TOT number is 290, and we paid our TOT. I don't know how it's proven, but we paid our TOT for any rental on the property, whether it was the guest house or the main house. And so I just wanted to clarify that fact. So that's for sure what we did. And then the workshop that we made a bedroom, be honest, I didn't even think about the designation differential from that being a workshop, studio, whatever, to a bedroom. But anyway, so yes, that was included in the rental of that main house. Subsequent to that, we added a pool and whatnot. So we always intend and always do follow the law as best we can. And I am not, it's not my expertise to take care of this. In fact, somebody else did my TOT calculations for me because it's just not my strength. I have to do other things, but to the best of my knowledge, it was 100% paid all through those years. And when we discovered that the short-term rentals were going to be eliminated in San Bernardino County, I wanted to make every effort to stay current by making an application for a homestay, which we did immediately, and including the application for ADU, because all of that seemed to be in my mind happening around the same time. So we got the homestay. In fact, all the letters went out to all the neighbors, and there was no complaints or, request for denial or anything like that. So it was approved. The ADU was also approved, and the error was on my part that we continued to rent the ADU on a short-term basis on weekends and whatnot. In fact, even some of my neighbors on my little road that connects to Figueroa Mountain Road, they would rent the guest house for functions like weddings and things, not weddings at my property, but people would stay here because of their family weddings. But anyway, those neighbors are very close to my house, and I'm at the end of the road, and we have never had any complaints. In fact, I've never had a complaint that I know of filed. And I've never met Mr. Rose, and I've never heard about any police. I don't know anything of the sorts. So it is upsetting to me because we've tried to be as compliant as possible. And as soon as when we filed for an extension of the homestay, which I believe we have to do every year, and noticed the neighbors, Mr. Rose contacted the county and said that I was in violation of the workshop as well as the ADU. So I got a call from the county and immediately took it off of the VRBO website. By the way, I only advertise VRBO. I don't advertise anywhere else. Never been on Airbnb, never been on any other site. I keep it just exclusively to just one simple site. That's it. But anyway, immediately we took it off from a 3-bedroom back to the 2-bedroom, which is just the main house, which you see on the floor plan. And at the same time, I was noticed by Kim Probert that the ADU is not legal to rent short term. So I immediately took it off of the rental, and I had already been living in the ADU. There were a few weekends when people were staying here, but as soon as Kim Probert asked or told me that it was illegal to short-term rent it, I stopped the rental and moved in myself, and I reside here as right now. In fact, that's where I'm speaking from. So we've made every attempt to be legal, and in fact, when we had the homestay application, part of environmental health was to verify that the well was up to the standards that are required in today's wells, and we discovered that the sanitary seal of concrete that goes down 50 feet was not adequate from the existing well. And so I spent $50,000 approximately to put a whole new well in. So we've spent probably, with all the different applications to stay current and to stay legal with the county, I would imagine $75,000, which is a large sum. But that's the intention that I've always had, is to stay current and legal through all my history and all my years of conducting business with the county planning as well as building. So that's kind of a short story of where I'm at.
Okay, thank you. Questions of the applicant, Commissioner Blau?
Not a question of the applicant, but a question of the county. I really sympathize with Mr. Trubocco having to do with a set of laws that are constantly changing, some by us, some by the state legislature. So the question for the county is there ever been an instance where they've contacted Mr. Trubocco for an alleged violation or shortfall or failure to act, and him not immediately make arrangements to remedy the violation or alleged violation?
Okay, Commissioner Blau, through the chair. We don't have any previous violations on our records for Mr. Trubocco's property. And as he stated, he was very compliant as soon as we contacted him about these violations.
Yeah, well, my actual question to you is, Ms. Mitchell, is if someone made a complaint about Mr. Trubocco's property and you contacted Mr. Trubocco, did he make arrangements to alleviate or the complaint or comply with any shortfall that might be there?
Commissioner Blau, through the chair, yes, he was compliant, and we did contact him, right when we received complaints from Mr. Rose. So there was follow-up and immediate action on that.
Thank you. Answered my question.
Yeah.
Okay, no more questions. Then we'll move on to public comment.
Thank you, Mr. Chair. We do have a handful of speakers. Our first speaker will be Denise Drucker.
Good morning. Can you hear me?
Yes.
Okay. Hi. My property abuts Mark's property on the west side of my property. I'm quite a bit away from him, and there's been a few incidences where it's a little different than Cali, but I'm not sure about the compatibility of a Airbnb where it is, or a VRBO, whatever you want to call it. And we have had for many years, when we're outside in the morning, we hear people yelling, people screaming in the swimming pool. So we hear quite a bit of noise. And if there was actually someone on site, as you're supposed to have with the homestay, you would expect them to keep the noise down. And it goes on, in the morning, and I think people leave sometime in the afternoon, but then there's kids there and they're yelling. And it seems to me it's more than 4 people. I can't be sure because I can't really see that far. The only thing is that prior to him taking the houses off of the VRBO site, I read the comments. And after he was not supposed to have more than 6 people or more than 4 people, I would read, the 6 of us had a great time. He was a great host, but the 6 of us had, and I kept thinking, well, why is there 6 people there when there's not supposed to be 6 people? So to me, that's bothersome. And then again, with the noise, if there was someone living on site, you would assume that they would, they would hear that and keep it down. But so far, and that hasn't been. So, I support the right to homestays. I don't have a problem with that at all. But if they're managed right and the rules are all followed, I'm fine with that. But if it's supposed to be 4 people and 6 show up, I know there's nothing he can possibly do about that. But, his VRBO says 4 people, 6 people show up. I'm not sure how that happens. And I'd like to keep the noise down. I'm sitting in my backyard and I hear people screaming. So that's bothersome to me. And I support Kelly's appeal in that sense. So I would like to see it to be managed better, closed down, or, it just managed a little better. So that's my opinion on the whole thing.
Thank you.
Thank you.
Mr. Chair, our next speaker will be Renee O'Neill, and then we also have a telephone caller after that.
Good afternoon. Can you hear me?
Yes.
Actually, I think it's still morning. It feels like afternoon. Anyways, I'm Renee O'Neill. I have been listening to the meeting. I was not planning on speaking to this agenda item. However, it raises concerns on other issues. I want to support Kelly Rose. I think he made some excellent points, and the previous speaker as well. When our county is moving forward with homestay rules, I think it's going to be extremely important to address where these are appropriate and where they may not be appropriate. In addition, I was triggered by Kelly's remarks regarding some businesses that seem to get away with operating, grading, clearing, building, etc., all done without permits, putting the cart before the horse. And this non-compliance with county ordinances that continues to go on in other industries is very upsetting to me. I agree with Kelly's remarks that various industries and businesses are allowed to proceed, do everything they're doing without getting the permits in place first, as are most other businesses and industries in our county. And so I'm mainly speaking to that. I really would like to encourage our county to enforce people who are not getting permits prior to operating, and also give fines, have consequences for those actions.
Okay, thank you, Ms. O'Neill.
All right, Mr. Chair, we do have one speaker who identified themselves earlier this morning. I see you unmuted yourself. Go ahead and if you could identify yourself for the record before you speak, that would be great. Thank you.
This is Kevin Kasich. Can you hear me?
Yes.
Great. My name's Kevin Kasich. I live at 3220 Figueroa Mountain Road. So I am directly south of the Trabuco property. Our house, the way it sits on, is on the very north section, and the area we're talking about, these houses or dwellings, are, from what I can tell, are located on the south. So we sort of are fairly close. My comment, which I will keep very brief, is really just a function of noise. And I am concerned. I just don't want to see it get worse. I don't think it's gotten to the level it has really bothered us. We definitely can hear it. So it changes sort of it becomes an issue that I would like to see being managed better. My attitude was, if it became a really bad problem or consistent, I'd reach out to Mark directly to handle. I haven't felt the need to do it, but in any of these things where you've got VRBOs and those, we all know that those can get out of hand. So my concern would be that this thing gets managed a whole lot tighter, so we don't have more than the allowed number of people on site. That's it.
Great, thank you.
Mr. Chair, that was our last speaker on this item.
Okay, great. Thank you, Mr. Villalobos. Back to the appellant. Do you have anything you'd like to add, Mr. Rose?
Yes, just a couple of things. It seems like Mr. Trabuco has presented this as being cooperative. Ms. Mitchell has talked about every time, I contact Mr. Trabuco, the people were very helpful and all that. I want to mention that in my package that I gave the Planning Commission, I included a September 30 email that's less than 30 days before the homestay was approved, noting the fact that although Planning and Development said the applicant was cooperative in obtaining a land use permit to convert the unpermitted cottage unit to a pool cabana and ceasing operation within the cabana in the ADU, September 30th, people were both at the ADU renting them out, and there were 3 couples at the main residence, 6 people. So although everybody agreed that there was lots of cooperation, nothing changed. And in November, a month after the permit was approved, the same thing occurred. There were 2 couples at the ADU and 3 couples at the main house. So I appreciate that everybody is very happy and that everybody is cooperating. But, the reality is it's not happening like that. Yes, Mr. Trabuco is at the ADU, has been there for the last several months. But, as I said way back when, although Mr. Trabuco talked about the TOT on the ADU, the tax collector requires a TOT for every structure that is rented out under the rules. the guest house / ADU has a separate address, 3346 Figueroa Mountain Road. It has no TOT. So while Mr. Trabucco may think that TOT has been paid on the guest house and the ADU, the reality is, according to the tax collector's office, Zippo has been paid on the guest house and ADU for the past 9 years. So whomever Mr. Trabucco is hired to stay on top of the problem is a little deficient. That's my only comment.
Thank you, Mr. Rose. Mr. Trabucco, do you have anything further?
Yeah, just to respond a few things on the TOT, that our TOT is $290, but we paid, and like I said this before, and of course it can be disputed and, analyzed or whatever, and it was obviously an error because it is a separate address, but the monies received from the BRBO guests were paid for both the main house and the guest house. So the monies were received to the county, and we can again dispute that, but I'm just speaking from my knowledge and what my intentions were. So I believe that money was paid. With regards to the noise, I put the pool in there for people to enjoy and for kids to enjoy, and it's unfortunate that people that live 1,000 feet away, even though I know like I can hear on the other side of Figueroa Mountain, Evergreen Ranch, has, mostly on weekends, the workers, I believe, have parties and it's whatever, have music and kids running around. It's okay for me. That's not, everybody has an opinion, but I just think that if you follow the rules and you have noise and it's not after 10 o'clock, and kids are playing or people are playing in the pool or playing whatever, that should be legal right, unless it's extremely obnoxious. We live out in the country here. I mean, the neighbors that have spoken, I don't know how far away we are from each other, but it's probably pretty far, like maybe 1,000 feet or maybe 800 feet. I don't know, but we come out here for a reason. That's to have peace and quiet. And so I've done the best to my ability to do that. And I've not had any neighbor call me for any complaints. And I've never had any complaints from the police or from the county for noise complaints or anything like that. I'm sure there has been times when people bring extra people, whatever, I don't know. But most of the time, like for an example, I just wanted to bring up my current guests. Right now, we have a couple who came back in 2013, 14, I don't know, their kids one child was born then, but now I meet my guests every time they come as best I can. And let's see, we're going to write that down. Oh, right here. Today, for this week, it's a parent with 2 children. First name is Matthew. Then the next people come, I believe, on Friday, and 2 parents with 2 kids. Her name is Holly. And then after that, we have 2 parents with 1 child, and his name is Christian. So that's the typical groups that we've been having, is been families, getting away from, cities and enjoying the peace and quiet of the countryside. So I would just say that I would, to the best of my ability, work harder to make mention to guests to be respectful to the neighbors with regards to any kind of music or outside noises or whatever. But I do believe in freedom, and I do know what the rules are in the county of Santa Barbara with regards to no noise after 10 o'clock. And of course, I think part of the record shows my welcome letter and requirements for no noise after 10 o'clock. So with that being said, let's see if there was anything else that I wanted to mention. I think that's it. but again, the most important thing with regards to the financial part of it, I just do everything I can to be as compliant as I can with the county. It's somewhat confusing for me. It's not my strength to go through all these processes, but I have done the best of my ability to be in compliance with regards to homestays and ADUs. And I will admit, I did not understand some of the technicalities of some of these changes. But as soon as the homestay was required, we applied, we, fixed the wells, did whatever we needed to do to get in compliance with that homestay. In fact, those letters went out to, I believe, all the neighbors that we've already mentioned, as well as the neighbors down my little road, who, by the way, really enjoy the guests that come here and ride the bicycles to town and whatever. So just on a positive note, that we have lovely neighbors down the little lane that are actually really close to me with no complaints, other than the fact that they really enjoy the guests. But my main focus would be to satisfy the distant neighbors for noise and try to mitigate that, especially in the evening hours. I think that's all my comment for now.
Okay, thank you, Mr. Trabucco. And then, does staff have anything they'd like to add?
Chair, I don't have anything to add at this time unless you have questions of staff.
Thank you, Ms. Mitchell. Okay, we'll turn it over to the planning commissioners. Commissioner Park.
I want to summarize some things here so we can move this along. And I see this as really two issues. One is compatibility and one is the transient occupant tax. Compatibility comes up in our homestay appeals commonly. And what I'm typically looking for is there a real uproar in the neighborhood about something. Are there some major problems? And if they are, then we might do something about that. And here we're hearing some comments from some folks that are more on the level of an annoyance rather than the kind of uproar I am typically more concerned about. And we do have a situation here where Mr. Trabucco is on site in the ADU, and he says he can do something about it and he will do something about it. So I think I'm not inclined to obstruct this permit on the basis of there being an incompatibility in the neighborhood. And I remind everybody, there's something unique about these homestay permits is that they're renewable each year. So you get a shot every year at claiming there's a problem. So let me move on to the transient occupancy tax issue. It's kind of a novel one for us. And it's essentially, Mr. Rose is saying, well, the guest house was an illegal rental for some years, and then it became an ADU, and ADUs aren't supposed to be used as a homestay, so it was used for that for so many years, and that that no transient occupancy tax was collected on the revenues from that. And on the other hand, we have Mr. Trabucco saying, well, actually, he reported and paid the transient occupancy tax on all revenues received from whatever structures on the property. So that's a question of fact that we're not equipped to resolve, and we're not actually even necessarily supposed to be the people who do resolve that. That seems to be a tax collector issue. If the Board of Supervisors wants us to look into that, then they probably ought to give us some direction or change the ordinance, or perhaps they can change the ordinance so it says who does look into that issue, because maybe they'd be concerned about the transient occupancy tax and whether it's being collected. But I don't think it's an issue for us to address. I think it's one for the board. I think that Mr. Rose has raised some good issues, and he may, if we deny his appeal, he may choose to appeal it to the board and let the board address that directly. do they want to do something to collect these taxes? But from what I've heard today, I cannot support the appeal. I think it's not really our jurisdiction to deal with the issues that are placed in front of us. So after hearing from the other commissioners, I will probably make a motion to deny the appeal.
Commissioner Blau?
Yeah, going along with what Commissioner Park had to say, let me give you a little more background, Commissioner Park. I'm not sure you were here when the short-term rental was done away with by the board. But I will tell you at the time that occurred, I vehemently argued to not do away with short-term rentals because of the tremendous revenue that it generated for the county. The tax department told us that at the point in time, I would think they were collecting about $1.4 million. And by everybody's best estimate, that was a third of what was due. And what I argued was, I thought it was incredibly short-sighted not to collect the other $2.5 million. It would have been easy. Get a couple of clerks in the tax assessor's office, get on the internet, look at all the Airbnb sites or anybody else that has the short-term rental programs. They give you the damn addresses, cross-check them against the TOT taxes are paid, and put out notices. And I'm not kidding you when I tell you there's a third of them that I think skirted it, a third of them didn't know, a third of them were paying. And what I found really incredible was you get testimony from the Airbnb people, and what they do is if the rental is $1,000 for the weekend, they add the 13%. They charge the $1,130. They send $1,130 to the $130 to the county and $1,000 to the resident. The owner of the property is not really paying the TUT tax. It's the tenant that's paying it because they do it as an add-on to the rental amount. So I will, and my other argument was that the reason that they did away with the short-term rentals were two. One was the perceived noise issue, and the second issue was that a majority of the board thought by having Airbnbs, they were shortening the rental market for workforce housing, which I think was a bogus argument, but didn't really matter. Mr. Trabuco's case, I think he has done everything he could possibly do to try and comply with the rules. And I feel sorry for anyone that has that kind of a property or a business because the rules keep changing. And I'm not sure that you're ever aware of it. I'm one of those, I understand that ignorance of the law is not the excuse, but ignorance of the changing law, I think, is an excuse. How can you keep up with those kind of changes that this county makes? And we know from the ADUs, I mean, we're sitting there for months trying to get our ordinances to comply with state law, and we think we have a new ordinance and a new flavor or a new tweak on it, and to help us make the neighbors not so unhappy with ADUs. Next week, the state comes back and says, nope, can't do that. Can't limit that, can't do that. You can't charge for connection fees, you can't charge for sewer fees, you can't do PD permits. It's just a permit by the building department. So I comply with that. I will tell you, Mr. Rose, that I absolutely sympathize with you. And I think what you should do is to contact the board member in your district and complain and ask them why are they not collecting the appropriate amount of TOT taxes if that's what's occurring. Again, it's so friggin' easy to do. Just go look at the websites for people that are advertising these kind of properties, cross-check the addresses to see if there's taxes being paid. If there's not, you send them a letter. Say, give me the rental income for your property for the past 3 years, show me where you've paid the TOT taxes, and if not, you just simply put a lien on the property. So Mr. Rose, you're right, but you're at the wrong venue to try and get that money collected. It should be at the board level or at the tax collector level, because planning and development has no control and no ability to collect it or even use it as I think, a condition for approval or denial. My thoughts.
Thank you, Commissioner Blau. There's Commissioner Brightly.
Well stated, both commissioners. When I read the staff report and I looked at the changing, I don't know what the game is called, where you put a thing under 3 cups and you keep on moving it around to vex your opponent to figure out where the truth is. I feel like this is what happened here. Now, it may have been innocent. I'm not so sure of that. I think that Mr. Trabucco is quite familiar with lots of county rules, and I don't know that this was so complicated to get through. But, if both Commissioner Park and Commissioner Blau are leaning that way, I can support the case and not the appeal, especially hearing from the appellant that his biggest concern is the transit occupancy tax, it appears, and that is out of our hands. I really also appreciate Commissioner Blau's background on that. The part that, if this is approved today, then I would really like to see the permit be very clear about permit compliance on this for both the appellant and maybe even some of the neighbors and even the applicant. It's not clear in your LUP conditions of approval how is the applicant hooked on these conditions and performance of them. That he has got to live in one of those units on the property. It's not, or hire a long-term tenant, right? We see that as a solution. But, I'm afraid that this will leave the hearing room today, and then Mr. Trabucco can choose to move back down to the South Coast and have all 3 units rented out in 2 months. And then what is the recourse of Mr. Rose or any of the neighbors that are concerned about it? Because we heard today the testimony was there's some annoyance factors. It was a good word by Commissioner Park about people being louder. Wouldn't it probably happen if there was an owner or an owner's representative on the property? So it's kind of a question back to staff about how do permit compliance things get hooked into the permit really clearly. Does anybody want to respond to that from staff?
Yeah, let's hear from staff, please.
Commissioner Bradley, through the chair. So permit compliance would not be applied to this permit. Typically, we don't require it for land use permits. And what that means is just an active permit compliance officer being assigned to it. So if there were issues that the neighbors noticed, they do have the option to file a zoning complaint, and that goes directly to our enforcement staff. And if there are multiple complaints and this issue keeps recurring, revocation of the permit is an option.
Okay, and so where in the conditions that talk about a renewal of this, I see the condition 11 about the permit revocation, building on what you just said, Ms. Mitchell, but is there an annual review of this like we have with other land use permits or no?
Commissioner Bradley, through the chair. The permit does expire 1 year from issuance date. So that's listed on the land use permit itself.
Oh, okay.
So they know that it's when it expires and that they have to reapply. So there is an annual review. Yeah.
Okay. Well, that was my concern. I think that this is not going to be smooth. I'm not convinced that the applicant is going to manage it as well as they could, but that's their option. And I agree that it's, we don't need to stand in the way of it, but I do have concerns about it. So that's it.
Commissioner Cooney.
Thank you, Mr. Chair. I'll just comment on the overview that I think while all of these neighbor-on-neighbor issues are difficult to side with one way or the other, I think the process worked here in that we do have what amounts to a short-term rental in the guise of a homestay. And it points out that what at least I thought we were doing with homestays was giving people a chance to participate in the agricultural benefits that many of our rural areas offer, is really just another place to go, and maybe a better place to go than a hotel in Santa Ynez or Solvang or other areas in our county. But Mr. Trabucco fortunately was able to state his position, which is he's busy. He can't keep an eye on all these things if there hasn't been tax paid. The payment of tax is not our concern. So I feel we have no choice but to back staff up in this position and deny the appeal. But the issues raised by the appellant are valid beyond this case, and hopefully they'll be addressed before we see another appeal. Thank you.
Thank you, Commissioner Cooney. Yeah, I agree with everything that's been said today by our commissioners. I think staff did a very thorough job, and they presented a very helpful presentation on what at first looked like a very difficult task. I also appreciate both the appellant and the applicant's presentations and the way they kept everything very civil. I think that's very important to keep life good in the neighborhood, if you will. So
here's what I found.
The one thing that I did that kind of struck me a little bit was when he did the applicant did the improvements to the well. He did spend $50,000 to get the well up to the proper sealing requirements as set forth by county health. And so I think he has a fair amount of risk here on needing to recover that capital investment. I think that will help him to follow the rules and be a good member of the community. So I'm ready to deny the appeal and support the project. Commissioner Park.
Yes, I want to make a motion, but just before that, though, I am reminded by Commissioner Bridley's comments to say something about the permitting here. I like to take a consistent approach. It may not look like that, but I like to everything, and certainly to these homestay appeals. And I think that I want the Planning Commission to take a consistent approach to them. One thing that I look for is, has the applicant filled out and filed a permit application for their homestay? And also, if the applicant has received a notice of violation from P&D about operating an illegal homestay without a permit, does the applicant file their permit and then shut it down while it's being determined whether they get the permit or not? And I don't like it when someone gets a notice of violation and keeps operating without their permit. But that's not the case here. Here, as soon as the ordinance was adopted for homestays in 2018, the applicant filed for the permit, got the permit, has been operating under a permit. There's been a question as to which structures have been properly included in that permit, and that goes back to the ADU thing. But this is not the kind of problem that gives me real concern. So with that being said, I will move that we adopt the staff's recommendations to deny the appeal and make the findings that are set forth in the staff report.
I will second that, but I will also make a small comment here. Commissioner Park, I consider myself as somewhat of an expert on projects and what permits are required and which ones are not. You cannot imagine how surprised I have been over the past year for additional permits that are required on the project that I had no knowledge of. It would blow your mind. And a lot of them are so minor you can't imagine. Like, okay, so I moved a friggin' signal light and I didn't get an encroachment permit for a 6-foot piece of concrete on the sidewalk. Now, it's only a $28 permit fee, but no, do we stop work on the project? I mean, I got a crew out there that's $1,000 a day. No, I'm not going to stop and wait 2 days and pay them $2,000 for a $28 permit. So I get it. I mean, when I look at an applicant or that doesn't file a permit, did he do it on purpose to avoid the permit fee, or was he just unknowledgeable about the fact that there was one? I give you a better one. In the city of Santa Maria, they were complaining to me about we're not getting permits for small tenant improvements. And well, part of the reason was, I mean, the tenant improvement fee was $1,000. It was taking them 6 to 9 weeks to issue the permit. And the rental on the, by the way, if you don't get the permit and they find you, you double the permit fees. Now it costs me $2,000. Well, 9 weeks of no rental income on the commercial building, $20,000. Now, what do you want to do? You want to risk losing $1,000 or lose $20,000 for certain. So therein kind of lies the problem. But in this case, I'm not finding any evidence of Mr. Trabucco purposely trying to avoid a permit or doing anything improper to have some kind of financial gain. At worst case, he didn't know he didn't need to do it, or stuck on him, or forgot about it. It's not like it was intentional to try and get some monetary gain. I second it, and I support denying the appeal, but this is kind of a shot over the bow of the county. You need to make it more apparent to them, and not be one where I appreciate the fact that they called me and said, Dan, you didn't get a permit for this. Really? How much is it? $28. Be there in 10 minutes. Whatever documentation you need. So it really depends on looking at the applicant to see, did he intentionally do it to try and get some big financial gain, or was it an oversight? Those are my only comments.
Thank you, Commissioner Blau. Mr. Villalobos.
Commissioner Cooney.
Aye.
Commissioner Bradley.
Muted.
Unmute.
Commissioner Bradley's muted.
Yes.
There you go.
Yes.
Commissioner Park.
Aye.
Commissioner Blau.
Aye.
Chair Farini.
Aye.
Motion passes 5-0.
Okay. Thank you, Mr. Villalobos. Well, let's go ahead and move on with item 4. And have Mr. Villalobos read that into the record, and then we'll at least get through staff presentation before lunch.
Thank you, Mr. Chair. The following is a hearing on the request of Tran applicant to consider case number 19 CUP 37, a request for approval of conditional use permit pursuant to sections 35.21.030 and 35.42.075 of the Land Use and Development Code. Mr. Chair, staff is just situating themselves.
Good morning, Commissioners. Ms. Vosberg will be the case planner for this project, and Ms. Vosberg, we're ready when you are.
Can you guys hear me okay?
Yes.
Awesome. So good afternoon, Chair Farini and members of the commission. My name is Aaliyah Vosberg, and I'll be presenting case number 19 CUP 37, which is a request on behalf of the applicant, Tran, to consider approval of a conditional use permit for the New Era LLC cannabis cultivation project. So the project site is located in Sabata Canyon, north of Highway 246, and approximately 5 miles east of Lompoc and 15 miles west of Buellton. Next slide. The proposed project involves a 100-acre parcel accessed off of the private portion of Sabata Canyon Road, shown in pink here, approximately 0.7 miles north of the terminus of the public portion of Sabata Canyon Road, and approximately 2.5 miles north of the intersection of Sabata Canyon and Highway 246. The property is located in the Ag 2100 zone district and is surrounded by properties zoned Ag 2100 to the north, east, and south, and Ag 2300 to the west. The nearest residential zone relative to the subject property, which is outlined in this map in yellow, is a rural residential area zoned RR10, located approximately 750 feet to the south and included within the boundaries of the Sabata Canyon and Tularosa Road EDRN, just shaded in gray here. Next slide. So in accordance with the Land Use and Development Code, the proposed project requires a major conditional use permit to allow cannabis activities on a property that requires use of a roadway through an EDRN as the sole means of access. Land use permits granted in compliance with the LUDC run with the land. So cannabis projects separately need a business license to operate, and the business license process considers more details of the operator that are not part of the land use permit process. Next slide. The proposed project is a commercial cannabis cultivation operation that includes 10.16 acres of outdoor or mature plant cannabis cultivation and 1.23 acres of cannabis nursery under proposed hoop structures. The cannabis operation will involve one harvest per year for a duration of 1 month. And in that time, all harvested cannabis will be immediately packed and transferred off-site for processing the same day it is harvested. And there will be no cannabis processing, meaning drying, curing, trimming, storing, finished packaging, or labeling on the project site. Support structures and improvements under the scope of the project include 8 proposed 80 square foot storage containers, 12 proposed 3,000 gallon water tanks, validation of 1 existing 10,000 gallon water tank, and installation of fencing, lighting, and parking. Additionally, an existing concrete pad on the property will be repurposed as a compost area. And this proposed operation will require 5 full-time employees and a maximum of 8 additional seasonal employees who would be on site for the duration of the month-long annual harvest. So this slide provides a site plan overview of the proposed project, which shows the cannabis will be cultivated in 5 distinct areas on the site. The 10.16 acres of mature plant cultivation is shown in green. The 1.23 acres of cannabis nursery is shown in yellow. The composting area is shown in orange, and the employee parking area is shown in magenta. Next slide. So this is a detail of the proposed nursery area provided here as an example. So each of the 5 distinct cannabis cultivation areas and the compost area will be individually secured with 6-foot tall wire mesh deer fencing, which is outlined here in red. And access to each area will be controlled with 6-foot high wire mesh gates that will remain locked at all times except during active ingress and egress. Additionally, proposed security lighting will include pole-mounted solar-powered security lights at each gate, providing access to the individually fenced areas, and 1 additional hardwired security light at the property entrance gate. The proposed security lights are highlighted here in yellow for reference, and all security light fixtures will be a maximum of 8 feet in height and will be fully shielded, directed downward, and motion activated to remain on for a maximum of 3 minutes after triggered. Next slide. So the proposed project will also implement a site transportation demand management plan that includes measures to reduce vehicle trips generated by the proposed project. Those measures include compressed work schedules for the 5 regular full-time employees, meaning those employees will work longer days and fewer days per week. And additionally, the 8 seasonal employees would be transported to the site via van pool. Also, the operation will use 20 to 24 foot sprinter vans for the purpose of transporting harvested cannabis offsite, which is projected to generate 6 sprinter van trips, which is 3 inbound, 3 outbound per day for a duration of 1 month per year during the harvest period. Next slide. The proposed project also includes an odor management plan prepared by SCS engineers that will implement project siting and design practices, operational best management practices, and vegetative environmental buffers to prevent project-generated nuisance odors from being experienced in residential zones. And as shown on the odor management plan, the topography of the site forms a bowl-shaped depression with hills sloping up to the north, south, and east, which forms a continuous ridge line across the south and east sides of the parcel. And the nearest residential zone relative to the proposed site is, again, a rural residential area zoned RR10, approximately 750 feet to the south, which is on the opposite side of the ridge line from the proposed cannabis cultivation operations. Next slide. So the proposed cultivation areas are situated in the bowl-shaped depression on the property at an elevation between 405 and 635 feet. The intervening ridgeline reaches an elevation of 655 feet. And the northernmost residence in the residential zone on the opposite side of that ridgeline is at an elevation of 487 feet. Next slide. So based on the project location, the regional meteorological patterns, site topography, and the project design, the project is expected to be dominated by 2 odor dispersal patterns. The first pattern occurs during calm conditions with periods of little to no wind and cool temperatures, generally 9 p.m. to 9 a.m. In this scenario, odors from cultivation areas would be expected to stay within the site's bowl-like terrain, with the most likely off-site migration of odor to occur as a drainage downslope to the west toward the private section of Sabata Canyon Road and the surrounding vineyards. Although there are no residential zoned lands or residences on agriculturally zoned properties in the vicinity of this drainage area, the easternmost cultivation area will be limited to nursery area, as was shown on the site plan, and that was recommended by the odor management plan. Next slide. And then the second odor dispersal scenario would be driven by higher wind conditions, generally 10 a.m. to 8 p.m., which almost exclusively travel from west to east. Although these higher winds have the ability to transport odorous air, they also hasten the dispersal and dilution of odors. So given the predominant wind pattern, odors not sufficiently reduced to background levels by this natural dispersion process would be expected to travel easterly to other agriculturally zoned areas rather than south to the rural residential zone receptors. Nevertheless, as recommended in the odor management plan, the project reduced the proposed southern extent of the southernmost outdoor cannabis cultivation area by 100 feet, which brought the area approximately 20 feet down in elevation. Next slide. The odor management plan also includes the installation of vegetative environmental buffers at the project site to further reduce odors beyond the dispersal and dilution already achieved through project design and siting. Vegetative environmental buffers have been successfully used to mitigate odors from agricultural facilities, including poultry and livestock operations. And as discussed in the odor management plan, comparable use of these VEBs can be effectively adapted for use in passively increasing the rate at which cannabis odors are dispersed and diluted as they leave the outdoor cultivation sources. Next slide. So the consideration for the commission today is whether the proposed project description complies with the LUDC and is consistent with the comprehensive plan. Sections 6.2 and 6.3 of the staff report provide a complete discussion of the project's consistency with the comp plan and the LUDC. And as discussed in the staff report, the proposed project is consistent with the standards of the LUDC, including requirements for the Ag 2 zone district and for the cannabis ordinance. Additionally, the proposed project is consistent with the policies of the comprehensive plan, including the land use element, services, hillside and watershed protection, and visual resources policies, the agricultural element, agricultural resources policies, and the conservation element, groundwater resources policies. As noted in the staff report, the estimated water use for irrigation under the proposed project is approximately 15.6 acre feet per year, which is an estimated 69% reduction from the property's historic use for irrigation while under the citrus and avocado orchards. Next slide. So the project relies on the PEIR prepared for the Cannabis Land Use Ordinance and Licensing Program pursuant to CEQA Guidelines Section 15162, as documented by the written checklist prepared pursuant to CEQA Guidelines 15168. This checklist is included as attachment to C to the staff report and demonstrates no additional environmental review is required for this project. Next slide. So with that, staff recommends that you make the required findings for approval included in attachment A of the staff report, determine that the PEIR is adequate and no additional environmental review is needed, and grant approval of the project subject to the conditions included as attachment B. And that completes staff's presentation, and we are available for any comments or questions.
Mr. Chair, I think you're on mute. We can't.
I'm on mute. Okay. I'm sorry. Commissioner Park, you're up.
But you know, if you want to mute yourself as chair and just sort of protest that way. I have a suggestion. I have a couple of questions, and they may lead to more questions and this and that. I think it would make more sense if I reserve my questions till after lunch, if you want to let us out to recess a little early.
So shall we go have lunch? Okay.
That's what I'm suggesting.
Okay. Commissioner Blau?
Well, I just looked at the attendee level. I'm guessing you've got about 25 minutes worth of public testimony. And I don't know how many questions Commissioner Park has. I don't have any. It would be a benefit to me if we just go through this. I'm guessing we could be done at the latest at 12:45, 1 o'clock.
No.
No, you don't think so?
No.
All right. Okay.
No.
If that's the case, let's break right now. Break right now for lunch, and come back an hour from now and get through it.
All right, we'll do that then. Okay. We'll see everyone.
Come back
And don't forget, the public might have thought that they weren't going to be hearing this item until 3:30 or 4. So we're still ahead of schedule, right?
Okay, well, that'll give everybody time to round up their troops.
Okay.
Okay.
Thank you.
Come back when?
1 hour.
Okay.
So 12:55.
Got it.
Okay, thank you.
Okay.
Mr. Chair, we're back on the air whenever you're ready to begin.
Okay, thank you, Mr. Villalobos. Okay, welcome back, everyone, and we'll reconvene here from our lunch break. And where we broke as staff had finished, and we were going to do questions of staff, and I think Commissioner Park was up to bat there. So, Commissioner Park, you're on. And Commissioner Park, I know I'm unmuted this time, so you can hear me.
There you are. And did we do ex parte disclosures?
No, Commissioner Bradley forgot to have us do that.
Thank you.
Oh,
so let's go to ex parte.
So for me, I met on the site with Stephen Peterson and Gilroy Macon, agents for the applicant, about 2 weeks ago. I spoke with Steve Junak in the neighborhood on the telephone. I met with Mr. Junak and Ron Johnson, the neighbor immediately to the north at Mr. Johnson's house yesterday. And then I had a brief telephone conversation with Mark Chitillo this morning.
Okay, very good. Thank you. Commissioner Bradley?
I had a site visit with Gilroy Macon and Stephen Peterson last week as well. That's all.
Okay, and I had the same site visit just a little bit before Commissioner Bradley with Gilroy Macon and Stephen Peterson. And I did speak briefly with Ron Johnson yesterday on the phone. Commissioner Cooney. And unmute, sir.
I had two conversations with Mr. Peterson, both about a potential Zoom meeting, but he had a medical emergency and had to cancel. So I didn't learn anything about the project from him.
Okay. Okay, now we'll go to Commissioner Park's questions.
Okay. Staff mentioned the prevailing wind direction coming from the west and blowing to the east over adjacent agricultural properties. I was at the Johnson residence, which is just to the north of the project, and the wind was blowing from the southwest right at me. And people tell me that the wind that's kind of blowing from the west, by the time it enters that canyon and is redirected by the topography, it's a prevailing wind from the southwest there. So was there a reason not to mention the Johnson residence just to the north of the property?
Commissioner Park, through the chair, not in particular. The prevailing wind direction information was directly from the odor abatement plan, which was prepared by a certified engineer. And I think the odor abatement plan does point out that residence. It just doesn't specifically call out it as the nearest residence itself. I think the odor abatement plan calls out specifically the nearest residential zone, and that residence is on an ag property. But again, it is pointed out in the figures of the odor abatement plan.
I'm glad you brought up the odor abatement plan. There's an odor abatement plan here because this is a major CUP project, correct?
That's correct.
Yeah. And the last time we had an odor abatement plan in a major CUP outdoor project was CCA. And that resulted in voluntary measures that were encouraged by the Planning Commission for adaptive management plan provisions, that if the if there were complaints made about odor and the applicant verified that they were following all the right procedures and it still wasn't working to redress the odor, then they would step up their use of technology, go to the best available control technology at that time, and do something more than what they were doing. And there they were required to have the buyer's outdoor system. Here I notice there's no odor abatement technology. I'm not necessarily considering that, criticizing that, just noting that there is none. And I'm wondering, are there similar adaptive management plan provisions as we saw in CCA, in which was praised by many of us as the platinum standard?
Yeah, so in the odor management plan for the project, you are correct. They do currently have proposed active odor management systems, but they do also have a section in the odor management plan that talks about contingency measures if there are 3 verified odor complaints, then they can, like you said, sort of step up their odor management. And one of the things mentioned also in that contingency measure section is potentially installing a vapor phase or buyer's odor abatement system as needed. But I think that the intention of the management plan was just to rely on the site topography and conditions of the site and the site design to manage odor so that it's not experienced in residential zones without having to put in a costly system if it's not necessary.
Do those conditions require the applicant to go to a hardware solution if the odor is not being abated under the current plan? That's what we saw with CCA.
I don't believe the language specifically says they would require to go to an active management system. I think it says that they would be required to abate the issue to the review and approval of the county if there are verified complaints. So I don't think it specifies that that abatement has to be an active management system.
Well, thank you. Let me ask the other commissioners. They want to ask their questions.
Commissioner Cooney, just checking your hand is up. There you are.
Apologize.
Okay, thank you. Commissioner Bradley.
Okay, so I have my standard question because it's always prompted by public comment often. We received a lot of letters for this case, but several of the letters actually talked about how the smell in Zapata Canyon right now is very bad. And I'm curious about what is already being grown in that canyon. I know that we considered herbal angels and that shouldn't be under production. So what other farms are nearby that might contribute to that experience that we're hearing from residents?
Commissioner Bradley, through the chair, we have the cannabis interactive map pulled up, and if CSB TV could project the monitor onto the meeting, we can kind of walk through the project location and surrounding areas. Thank you. So the project site, as Ms. Vosberg noted, is located just north of this EDRN. This is the project location. Just for context, this is the Herbal Angels project that the commission heard about a year ago. And then within the EDRN, these are 2 former cannabis application sites. In December, county staff, in conjunction with the sheriff, went on site to verify that they are no longer growing cannabis. And to date, that is our understanding, no cannabis is grown. To the northeast, there are these 4 dots. I will zoom in a little more for the commission here. This yellow dot shows a project that has been approved and is currently operational. There are 3 other properties just south. 2 of these, High Meadows and Clear Source have provisional licenses and have the potential to grow at this time. The last time county staff was on the southern site, Clear Source was, I want to say, end of 2020, and there was no cannabis on site at that time. However, they do have provisional licenses from the state. And the other project here is Hall Outdoor Cannabis Cultivation. They have an approved land use permit, but it has not been issued, and they are working through the business license portion, and they are not currently growing. Once again, those projects are just northeast of the proposed new Era site.
Okay. And I mean, maybe the public can eliminate us from there when we get to that point of it. But so just to make sure I have my bearings on this, we're in a CUP process because it's cannabis and that's what the code requires. And if someone else wanted to come into this farm and grow broccoli or cherimoyas or whatever, there would be no public hearing, right? There would be no public hearing, no review of water use. It would just be right, use by right under the Ag 2 zone district, right? Unless someone wanted to put a building close to a setback line or something, right? There's nothing operationally that controls any other kind of crop other than cannabis, right?
Commissioner Bradley, through the chair, that is correct. If the applicants wanted to farm broccoli or strawberries or any other type of agriculture, that generally does not require a permit. And why I say generally is, if they are proposing hoop structures of a certain height, they do need to come in for a land use permit. But for the most part, I would say you are accurate in that statement that the county would not require a permit for the crop type aside from cannabis.
Okay. And the second thing, or third thing I actually want to ask about was when I was out on the site visit, the agents mentioned something about these pre-existing polygons on the property that were recorded with the parcel map many years ago that already protect oak woodland and a couple other habitat areas. Did you have a slide of that? And maybe this is something that the applicant's going to explain, but it was helpful to see where those protected areas were in this site and where the cannabis grows are proposed, that they're not overlapping.
Commissioner, go ahead, Ms. Vosberg.
Commissioner Bradley, through the chair, I don't believe that we have a specific slide to showing those areas. I do believe that the applicant's presentation will, but those areas are also shown on the plan set, I believe on sheet 1.
Okay.
And that the proposed cannabis areas under the project are all set back a minimum of 50 feet from the edge of those conservation areas, in addition to, or I should say, as well as 50 feet from the edge of other oak woodland habitat on the property that's not included in the conservation areas.
Okay. I think that's probably it for my questions. Thank you.
Okay, seeing no further questions, then let's move on to the applicant presentation.
Good afternoon, Chair Farini and members of the commission. My name is Stephen Peterson, and today it's my pleasure to present to you the New Era Cannabis Cultivation Project. First of all, we would like to thank the commission for your time and careful consideration and review of our project. And also we'd like to thank the planning staff at Planning and Development, especially our planner, Aaliyah Vosberg, for all their help over the past 2 years and moving us through this process to the point we're at today. As we embark on this conversation, we're all aware that there was another cannabis project in the area reviewed by the Planning Commission not too long ago, and it's important to remember that our project is not that project, and that this project is quite different from that other well-known project in the neighborhood in several important ways. The New Era project is very different from the other project in terms of the location of the site in relation to the EDRNs and surrounding residences. It's different in terms of the public visibility of the site. It's different in terms of the intensity of development that is being proposed, and very different in terms of the intensity of the operation that is proposed. Next slide, please. First of all, I'd like to introduce our team today. Gary Wolf is the property owner. Mr. Wolf has owned the property since the late 1980s and farmed citrus and avocados on the site. Also today we have with us Mr. Tu Tran, the applicant. He'll be speaking in just a moment. Additionally, we have Gelare Macon, principal planner here at Flowers and Associates, that may say a few words. Also, Nathan Eady is our odor control specialist. He's with SCS Engineers, and he's available via Zoom today to respond to any detailed questions regarding odor abatement. And finally, we have our biologist, Thea Benson, who is also available on Zoom today if any bio issues come up. So at this time, it's my pleasure to introduce to you Mr. Tu Tran, who has a few brief words for you.
Thank you, Stephen. Good afternoon, Mr. Chair and Commissioners. My name is Tu Tran, and I'm an applicant for this project. First, I would like to thank the Commission for your time and attention to our project. I also like to thank the Planning Commission, Planning Department, staff, and especially our planner, Aaliyah Vosberg, for the helpful and professional job that they have done over the past 2 years to help us get to where we're at right now. I will leave a bulk presentation today for Mr. Peterson, but I just want to take a moment to introduce myself to you and let you know about our goals with this project. A little bit about myself. I live in San Jose my whole life. I was able to make some money in the tech industry. It allows me to take time to venture off into other businesses of my own. So I decided to move into the cannabis industry, and as right now, I'm currently involved in 2 cannabis projects, one in Monterey County and the other one in San Luis Obispo County, and this would be my 3rd project. I came to Santa Barbara after I found out the possibility of growing cannabis outdoors. As I was looking for a site, I was fortunate enough to meet Mr. Gary Wolf. Gary has farmed on his property on Sabata Canyon for some time now, since the late 1980s. But as he's getting older, he is looking to take a less role in the operation, but wishes to maintain his property in agriculture. After getting to know Gary, he has expressed his interest in cannabis and offered to lease the property to us. Coming into this hearing, I understand that there are concerns that most residents have, and we understand that Sabata Canyon is a very special and very beautiful place with longtime residents that have a tight-knit community, and they wish for it to remain that way. So we want to be good neighbors and fit in, and we want to make our project as minimal as possible. We spent the past year working with a team at Flowers and Associate to design our project to be of small scale and to have as minimal impact as possible. Our project emphasized on being responsive to neighbors' concerns, to preserve the neighborhoods, and to be compatible with the area. Throughout the process, we work with Flowers and Associates, as well as many older consultants, engineers, and biologists to meet this objective. Based on the expert recommendations, we have revised our project numerous times just to accomplish these goals. We have put a lot of thought into this, addressing all current and potential concerns. We have intentions to be good neighbors, and we will continue to be open to make further adjustments to our project if necessary. Again, I appreciate your time, and I will now turn it back to Mr. Stephen Peterson. Thank you.
Thank you, too. Next slide, please. So as two mentioned, we have listened to the neighbors and their concerns very carefully in this project and tried to address their concerns and tailor it to be a low impact and compatible project with the neighborhood. We have a 100-acre parcel here that we're only proposing 10.16 acres of cultivation and a 1.23 acre nursery area. So you've got a lot of buffer space there. We are not proposing any on-site processing. All product will be removed immediately after harvest for processing elsewhere. No new buildings are proposed here. We are proposing only one annual harvest. As you know, typically these outdoor projects have been proposing 3 harvests per year. We are proposing only one. We have also written into the project description that we will only be using Sprinter vans for product transport. These are smaller, less impactful vehicles. We've designed and cited the project to minimize odor impacts, and we'll talk about that in more depth later. We've written the site transportation demand management plan to the van pool for all the temporary harvest time employees. And we've included flex scheduling so that under normal circumstances, no more than 3 or 4 employees will be on the site on any one day. And then finally, the project has reduced water use from what has historically been used there for the avocado and citrus farm. And I'll touch on some of these points in a little more depth as I move forward. Next slide, please. First of all, regarding the light use of the site, and this touches on Commissioner Bridley's question, when the property was subdivided, the county placed a condition for a conservation easement area on the property, which is outlined in this map. Those are areas that can't be developed and need to be preserved. And that comprises about 18% of the site, as you can see on this map. Next slide, please. In addition to that, when we had our biologists come out and review the site for this project, she found an abundance of coast live oak woodland habitat areas. That comprises about 39% of the site. And she recommended that we avoid these areas completely and leave them untouched, which we've agreed to do. Next slide, please. In addition, Ms. Benson identified about 16.65 acres of black sage habitat area, which we also plan to preserve. And next slide, please. On top of that, we included 50-foot setbacks from these habitat areas. Typically, the county requires a 25-foot setback off of these kinds of habitats. Just to be cautious, we built in 50-foot setbacks and agreed that we would leave those areas untouched, and that comprises about 15% of the site. Next slide, please. In addition, there are some individual oak trees that did not qualify as oak woodland areas, but still need to be protected as individual trees. And for those individual trees, per the county's guidelines, we are setting back at least 6 feet outside of the drip line of those trees. That you can see that shown on purple here. Next slide, please. This is putting all those colors together of the protected areas. Some of them overlap a little bit. And next slide, please. This brings you to the total situation where we're proposing preserving and protecting 73% of the site and not touching it, which of course would be locked in as part of our project description, and which is not something that you could achieve with forms of agriculture on the site that would be able to develop more extensively. So we feel like that's a big deal for preserving the character of the neighborhood to lock in 73% protection of the site, including all of the major habitat barrier areas and generous buffers from them, proposing no tree removal. We believe that's a pretty significant plus for the project. Next slide, please. As I said, we intend to make this project as low impact and compatible as possible. With no on-site processing, as we all know, the processing is often the most impactful part of the cannabis operation in terms of odors and activity on the site, and it can generate a lot of traffic. So we have no processing whatsoever proposed on this project. In addition, as I mentioned, we have 1 harvest per year recommended or proposed. As we all know, the harvest time is also another time that produces odor and activity and trips on the site. So we've only proposed 1 year. It would be 1 month long, and it would be in the fall. Applicants here are proposing kind of a traditional old-fashioned style of grow where they plant the crop in the springtime and they harvest it in the fall, and it's just 1 crop, 1 cycle. Finally, as I touched on before, we have no new buildings proposed as part of this project, and actually we're going to demolish 4 existing buildings on the site, so there will be less building development on the property with this project than there is now. Next slide, please. Wanted to highlight the use of Sprinter vans because we understand that Sabata Canyon Road is a narrow rural road with narrow shoulders. And so to be less impactful to that road, we've proposed limiting our product distribution off of the site to using Sprinter vans only. Here's a couple of photos of what Sprinter vans look like. You can see that they're pretty much a typical van like you'd see anywhere. And our harvest plan would be 3 trips per day by Sprinter van to remove the product from the site. And that was calculated with figuring out how much each acre would generate, how much we could fit into each sealed plastic container, and how many sealed plastic containers we could fit into a Sprinter van. So we've just got 3 per. Next slide, please. Just wanted to highlight some of the information about the surrounding area there and the isolation, if you will, of the site. You can see Sabata Canyon Road shown on the map. The yellow portion of it is the public portion, and the green portion is private. So you can see that the road turns to private. I believe it's 3/4 of a mile before you get to our property. So we're on a private stretch of road there. Also, you can see in the brown on here is the nearest residentially zoned area, and that's 1,200 feet to the south from our property line. The purple is indicating that everything else around here are agriculturally zoned parcels. And I think, as Ms. Vosberg already mentioned, we're not within nor directly adjacent to either of the 2 EDRNs that are around there. And then I wanted to highlight the location of the Johnson's property, which they're the nearest neighbors directly to the north of us. This map is a little bit small, but you can see that it's 620 feet from it's 630 feet, 630 feet from the edge of cultivation area 4 to their residence. And I had our engineers go back and check it this morning, as I know this is an important issue, and they confirmed that the closest point of the cannabis grow area to the property line, to the Johnson's property line, is 75 feet. And that's just to the Johnson's property line. If you're going in a straight line from the cultivation area to their home, it's 165 feet till you hit their property line, and it's the 630 feet from the cultivation area to their home. Okay, moving on to the next slide, please. This map just illustrates the topography that I think you're mostly familiar with and the predominant wind direction. On this map, the highest elevation areas are the red areas, medium are the yellow, and green are the lowest areas, so that you can see that the project site is located in a concave bowl. And with the predominant wind direction coming from the west, is going to serve to contain odors within the bowl and is one of the key tenets of our odor abatement plan. Mr. Eady is available to speak in more depth about the odor abatement plan. Next slide, please. That's just a little bit of a zoom in on the topography of the site to give you a sense of the bowl shape. Next slide, please. When SCS engineers and Mr. E, the odor abatement plan, they came back with some recommendations to help make the project less impactful. The first thing I'll draw your attention to is the green area. That's cultivate area 1. It was originally proposed as a cultivate area. Mr. Eady recommended that since it's near Sabata Canyon Road and in cold, cooler weather times when there's not the prevailing winds, sometimes odors can drain or kind of sink down. So he thought in order to prevent any odor from draining down or sinking down to where it would be smelled on Sabata Canyon Road,
Get something done.
that we should not have cultivation there. So he recommended that we change the green area to just a nursery area where there are baby plants that aren't smelling so much. So we took that recommendation. Additionally, the blue area on the map at the bottom, here he recommended that we pull the cannabis cultivation area 100 feet farther back down the hillside to ensure that no odor would blow over the ridge line. The ridge line is shown on there with a red line. That's where the ridge line is. Took that advice and we moved the project down farther away from the property line. So it's 150 feet from the property line up there and 100 feet from the ridge line up there. Slide, please. We also did vegetative environmental buffers designed to catch and dilute any odors. And slide, please. And I think it's about the vegetative environmental buffers in some depth already, so we can move beyond that one. And here I just wanted to mention the water use, and this is the last slide. We're anticipating 9% reduction in agricultural water use on the site. On this map, you can see in the yellow is the areas that were previously citrus orchard, and in the pinkish areas, you see the areas that were previously avocado orchard, which is 23.3 acres in the past historically. And you can see the blue or purple areas are where we have proposed for cannabis. So we've limited these areas to previously cultivated areas and a lot less acreage than before. So this has reduced anticipated water use by 69%, we're anticipating. Next slide, please. That brings me to the end of my presentation, and we're available here for any questions that you might have. Thank you very much.
Thank you for the presentation. A question, is Mr. Edie available? Should there be questions about smell and odor and wind directions?
Sure. Yes, Mr. Edie is on the Zoom, so you can call on him at any time with a question.
Okay, very good. Thank you. Questions of the commission?
So are they done?
Yes, sir.
Okay.
Go ahead, Commissioner Park.
So I heard, Mr. Peterson, when I met with you, there were two owners of the applicant. Now I've been identified as one, Mr. Tutran, but who's the other?
Mr. Tran is the applicant. He has a couple of other partners that are more partners who've invested in the business. Adrian Medina is the name of one of them, but they're minor partners. Mr. Tran is the applicant.
Yeah, I don't think you're answering my question. You told me at the site there were two owners, and I asked him to meet them, and that didn't come to play. And so now you're telling me Mr. Tutran is the applicant. I'm just trying to find out who's the owners.
Are you talking?
If you're trying to avoid comparison with Herbal Angels, that's a good way to avoid it, is to answer the question.
I think I missed Commissioner Park through Chair Farini. Maybe I misunderstood the question. You're talking about the owner of the property, Mr. Wolf.
No, of course I'm not asking about the owner of the property. I'm referring to the comments that you made to me at the site that there were two owners of New Era, and I asked to meet them, and I've now been identified that Tutran is one of them, or he's the applicant. I don't know if that he's an owner or not. And then you said there's some other people that are minor owners. Who is the owner? This is something that the neighborhood is very curious about.
The owner is Tutran, and he has a minor partner who is Adrian Medina that is a smaller investor in his endeavor, but Tutran's the owner.
Okay, so Mr. Medina was the other person you were referring to when we met at the site?
Yeah, that's correct.
And New Era LLC, what role does it have with this application?
The applicant for the project is Tran. They registered to get an LLC called New Era with the business, and during the pandemic time, their accountant didn't file one of the tax papers that was required, so the LLCs kicked into suspended active status, and we're working to resolve that at this time.
Okay.
So
that involves a simple payment. Thank you.
Commissioner Park, I think there's a couple papers to submit. Did you want to say anything about that too? You have two, he knows.
Hi, Commissioner Park. One of our old accountants, they forgot to file taxes through the FTB. So we just recently hired another CPA who was on top of it, and he started filing for all the paperwork. And he also he gave us a memo. If you guys are interested, I can email to you guys later on, or anybody who wants it.
Well, Ms. Vosberg already has that memo from the accountant talking about how they're going to submit the missing tax form to get the LLC activated again.
Okay. Let's see here. I don't see any further questions from the commission. Does staff have anything they'd like to add at this time?
Not at this time, thank you.
I have, if I may, quickly. I have two
Yes,
things
please.
I wanted to mention. I think earlier Commissioner Park had asked a question about the why the residents north of the site, I think the Johnson residence was not specifically called out in the odor abatement plan. I guess to clarify our response to that question, I just wanted to mention that I think part of the reason for that is while they identify it as the nearest agricultural receptor because it's on an agricultural zone property, I think the odor abatement plan calls out the nearest residential zone because that is the code requirement for odor abatement in the LUDC. It specifies prevention of odor from being experienced in residential zones. And then the other thing I just wanted to clarify was I think I misspoke. Again, I think Commissioner Park had asked for the corrective actions if they were required to implement an active odor management system.
Exactly.
While the code language does not require that, and our condition language does not explicitly call that out, their odor abatement plan does specify that their corrective action would be an active system. That's all.
Okay. Mr. Villalobos?
Yes, Mr. Chair. Did you want me to start calling on?
No, not yet. Would you look? You sent an email to us a while ago, and it was an attachment, and it had to do with New Era's standing with the Secretary of State of California.
Yes. Would you like me to?
Is there a way you could put that up on the screen so all of the other commissioners could review that?
Sure. Just give us 1 minute.
Thank you. In split screen.
All right. We have it pulled up. If our TV staff could. There we go. Thank you so much.
Can't read it.
That's the problem. Ms. Vosberg, could you read that? Just
Maybe Miss Blair can help me out. It's a little small for me.
you can't read it either.
But it was emailed to us?
Commissioner.
Yes.
I will do my best to read this. This is a web printout from the California Secretary of State, and what it shows is the results of a business search entity detail for New Era. It gives the registration date, the entity type, the status, which I believe was the point of this submission. It shows as suspended. It includes the entity address, mailing address, and LLC management. And then there's some just general information below here. Information requests, search tips, frequently asked questions. Do the commissioners have any specific questions regarding this visual?
I would just note that under document type that says SI complete on 5/24/21. So it does appear that the applicant has attempted to update their filing, but but up on the top of the sheet it says that this is only updated. They haven't updated the information yet. The state hasn't, but it does look like there's been a filing. Mr. Wilson.
Mr. Chair and Commissioners, I know we've been spending some time exploring this avenue, and I'd like to refer to staff potentially and maybe potentially having council support my comments in that. As far as the application before you and the records before you, Mr. Tru Chan is indicated that he's listed as the applicant and operator. And New Era is only showing up, I think, in one of the documents. So the entity applying for this is not New Era. And I know there's been a lot of questions and concern or consternation about the status of that entity. But as far as the record and application, I think it's Tu Tran is the actual applicant and operator that's signed all the documents and stuff. He did that as an individual, not on behalf of the entity. So as far as what is presented to the commission and the action, I think Mr. Peterson indicated and the applicant's team that the person who's actually representing the operation is Tu Tran, not New Era. That how that entity comes into existence or its status isn't at this point relevant because it isn't the applicant on this particular application.
Thank you, Mr. Wilson. Commissioner Blau.
Yeah, I just want to comment that if I understand this, and county council could correct me if I'm wrong, but it doesn't matter who the applicant is, to tell you the truth. At this point, we are giving a land use permit or a CUP for the property, which goes with the property, regardless of who owns the property. Now, this is why it's important to understand Commissioner Bridley's request earlier to get the part of the county that gives a license for the operation of it. So it's like, although I appreciate Commissioner Parks wanted to know who the owners are, the reality is we have an owner of the property. He has given consent to Tran to make the application for the operation, but we are actually giving approval to the property owner. And if the current applicant that's in here sells the operation the day after our approval to another operator, we have no control over that. They don't get to come back and we don't get to review it. We are making conditions for the property, not for the operation itself. If I'm wrong, county council needs to correct me.
Chair for
Ms. Richardson.
Commissioner Blau, through the chair, that's correct. So the land use permit runs with the land. So conditions should be based on the property. And then for cannabis projects, the business license process looks at the actual operator of the project, the applicant. So at that point, if New Era LLC is the applicant for the business license, then there may be some details to be worked out, or I'm not sure if Mr. Tran proposes to individually be the applicant, but either way, it's outside of the land use permit and conditional use permit process.
I just want to reiterate this, how much I appreciate Commissioner Bridley's suggestion that we have them come in here and give us an update as to what they do and understand the separation of the two operations within the county.
Okay, that was helpful for me. Thank you. Mr. Villalobos, let's move on to public comment, please. Do you know how many speakers we have?
Mr. Chair, I'm showing 11 speakers.
Okay.
I'm sorry, it looks like maybe 10. There's a repeat here. Just because he's been so patient, I'm going to call on Louis Shaw first.
All right, we'll go with 3 minutes, please.
Mr. Shaw, if you could unmute yourself.
Yes, I am unmuted. Am I able to be heard?
Yeah, go ahead, sir.
Okay. I know Mr. Dutran for approximately 2 to almost 3 years. He has been a very upstanding citizen. He has been involved in fundraisers that have taken place for various schools that put together a project once a year that is known as the World Games, which 10,000 people that we also give scholarships to 10 individuals. He's also donated his time and coming in a tremendous amount of help. This was before to his character and volume. Be a very credible person, true to his word and to his commitment, because when you are asking people to come in and to volunteer and to be part of something of that magnitude, it is very important that their commitment be there, because there isn't any money involved. And he has been truly outstanding to that. So I believe whatever endeavors that he will be doing with his business will be forthcoming, and a very good person to be able to complete what it is that he says he's going to do. And for the years that I am going to do. So, thank you for allowing me to be able to speak. I appreciate that very much.
Mr. Lewis, I'm not sure if you're in your car, but your connection was coming in and out. So did you want to maybe take the opportunity to just give like a couple sentence summary just to make sure that we got your point across?
I am in the car, and unfortunately, it's been a long day. I actually tuned in at 9 a.m. this morning. But actually, you wanted me to repeat what I've said? Was that the question that you presented to me?
That's up to you. I know that we only have a certain amount of time, but did you want to take the opportunity to, give a summary of what you said, just to make sure that the Planning Commission heard what you were trying to say?
Sure. I said for the last 2.5 to almost 3 years, I've known the applicant, and we have known him in the capacity of him volunteering and helping with the very large event that takes place once a year that attracts over about 10,000 people from various different schools, communities, and we raise funds and produce scholarships for these kids. And he has donated his time, his efforts, and this was before I knew anything about what he's doing, about his planning, so it had nothing to do with that. His word, his commitment was very important because there is no money involved. It's all volunteering. So when you have someone that makes that commitment and does that, it's very important to us. And we've been doing that for almost 16 years. And he has come in the last year, and he has participated and has helped, very greatly. So I endorse him as an individual, to be honest, forthcoming, and to be an upright citizen. He has made commitments to helping with that fundraising project that we do, and he was right where he needed to be and did the things that he said he was going to do, and that was very important, for us. So I truly endorse him as a honest, upright citizen, and I think his commitment to whatever it is that he's committing to do, that he would do it. And that's important because we only are involved with people that will be able to do that in terms of helping with our program that we do once a year, because it's a very major program to us. We give out about 10 scholarships to kids, and so it's a very important program to us. And he came in and did everything that he said he was going to do. So we find him to be very credible as an individual. Thank you for allowing me to be able to speak.
Thank you, Mr. Shaw. That was much more clear that second time.
Okay.
Our next speaker will be Lee Johnson. Ms. Johnson, if you could unmute yourself. We'll come back to Ms. Johnson. Our next speaker will be Steve Junak.
Thank you. Can you hear me? You can. Great. Thank you so much. Good afternoon, Chair Farini and commissioners. I'm a resident of Sabata Canyon and also a retired botanist with 40 years of experience. That's important for the rest of my comments today because I'm going to comment on the botanical resources assessment that was done on the property. I won't repeat a lot of concerns that other neighbors have about the incompatibility with the neighborhood. But I also would like to say that the traffic is a very real problem, and we're really concerned about increased traffic on our narrow winding road, which has a lot of blind corners on it. Just a couple of months ago, there were 4 dead deer right at the junction of the private section of Sabata Canyon Road and the paved section. 4 dead deer were killed in just one traffic accident there. And it was really upsetting to see that. But anyway, the botanical resources assessment that was conducted on the property appears to have significant problems. The plant list only includes 40 species. 43 were actually listed, but 3 of them were listed twice. And that's for an area 11 acres in size. That's a very small number of species for a study site that's the size of 8 football fields and probably has numerous omissions. For example, none of the common non-native grasses, the foxtails, all kinds of other common grasses that you find throughout the coastal part of Santa Barbara County were not even included in the survey. In addition to the suspiciously low number of plant species reported on site, there were numerous errors in the list that was compiled. 2 native plant species were listed as non-natives, and those are itemized in a letter that I mailed to you. Several species are listed that are not known from this part of Santa Barbara County and have probably been misidentified, and those are also specified in my letter to the commissioners. Most importantly, a very important bunchgrass, actually the genus Stipa is our official state grass of California, was reportedly found on the property, but its location was not mapped, and there is no mention of its abundance on site. As I'm sure you know, native grassland habitats are protected in Santa Barbara County if native grasses are found to comprise 10% or more of the total relative plant cover there. And that's according to Santa Barbara County's Environmental Thresholds and Guidelines Manual. The native grasses that were found on site need to be mapped and investigated further before any project is approved at this location. If this project does move forward, I hope that you will require that they provide a more complete survey of plants online and also add some additional requirements to the conditions of approval. One of these would be, I'm really concerned about the effects of nighttime lighting, especially at the Johnson residence. If lights are coming on and off all night, it's going to be very disturbing for them, especially because they can virtually see the whole property from the edge of their property. The nursery on site, is that going to be operated all year long? It'd be great to specify exactly when that's going to be operated. And are the applicants going to be able to sell those nursery plants that they're growing on site to other growers, or are they only going to be using those plants on site? If they're going to be sold to other growers, that's going to really increase the traffic and has not really been addressed in the study.
Thank you, Mr. Junet.
Thank you.
Our next speaker will be David Clary. Mr. Clary, if you could unmute yourself.
Okay, have I unmuted myself?
Yes.
I guess I did. Okay, good. Good to see you, Commissioner Blau. I'm glad you're doing
Good to
better.
see you.
Yeah. I wanted to start off by saying I think it's a major problem and has been for quite a while to not have a clear idea of who the applicant is. It may be a land use permit, and so you're focused more on the use of the land, not the person. But do you really want to risk giving a land use permit to a company that has been suspended? And that's not the risk here because of what Jeff Wilson said. But look at your publications. The staff report says it's a hearing on the request of Tutran applicant to consider a request for approval of the New Era LLC cannabis cultivation conditional use permit. That leads to an enormous amount of confusion. In Tepesquay Canyon, where I live and my wife lives, there's one fellow who on the application, he's stated as a financially responsible person, the owner of the land in that case, but the owner of the land in this case is someone else. But in nowhere does it state anything about any LLC being involved. Yet all the other documents were filed on behalf of an LLC. So finally, and then he changed the LLC. So now he's filed everything under, and he's changed. He says, no, this LLC is going to be the applicant. He only responded to that and made that decision when specifically asked which LLC or party is going to be the applicant. Now, after 2 years. So this needs to be clarified. You don't want to risk, this is apparently not for an LLC, but there's no way for anybody to know that in advance until Mr. Wilson just said that. And it's just plain enormously confusing. I hope that the county takes that into consideration and looks at it. I support our friends in Sabata Canyon who have over and over again said the noise, the dust, all the issues regarding the transportation through the road, through the EDRN is a serious problem. And the case law saying that the considerations of the neighbors are extremely important in considering LUSC. Thank you.
Thank you.
Our next speaker will be Susan Stevens.
Hi, can you hear me?
Yes.
Can you hear me?
Yes.
Okay, great. Thank you. Okay, I just wasn't sure if I should just go ahead and read the letter that I submitted or make comments on what I've seen thus far.
You have 3 minutes.
Okay. First of all, I'm concerned with Tutran saying that his CPA forgot to file taxes. That's what we pay our CPAs to do, and just to forget to file them. Anyway, our main concern is fire. Living in Sabata Canyon, it's a small winding road, blind corners serving a rural neighborhood. It wasn't constructed for heavy commercial traffic or the larger vehicles that go along with it. Currently, some edges of the road are disintegrating. This road's also the only road in and out of our canyon. With this much added traffic, and I realize they're saying they're going to use Sprinter vans, but I think common sense and also history has shown that there's going to be a lot more traffic than what they're leading us to believe. And in the event of fire, a serious threat of not being able to exit the canyon in time is going to exist. Previous evacuations of the canyon have shown difficulty just with the many horse trailers exiting during an evacuation order. Second, blind corners. When I first moved at the canyon, I had to navigate the intersection of Sabata Canyon and Avena roads. Basically, I approach the turn, and then once I'm committed to the turn, I speed up to make it through safely before an oncoming car comes from around this blind corner. More and larger vehicles associated with this commercial grow will further burden this tricky intersection. Residents of the canyon know the intersection and how best to navigate it. Third is safety. Currently, we've already mentioned that this New Era LLC has been brought up as suspended. That's made us question their credibility. Also, apparently a comment was made from New Era to a canyon resident that they would have only one harvest per year. However, then they noted 2 in their cup application. We have somebody in the business that's a personal friend, and they said the reality is 3, possibly 4 harvests a year if they're really go-getters. And this individual also informed us that 5 employees is definitely not enough to run an 11+ acre of plant maintenance. We feel that this applicant's not being entirely straightforward. Time has shown that neighbors of large grows become highly vulnerable, and apparently our current cannabis compliance team is understaffed. This is unsettling since unchecked grows have shown to be extremely dangerous in terms of crime, and then the remote location of the canyon is going to only increase this danger. And lastly, children. We have a school bus transferring kids in and out of the canyon. It stops immediately in front of the mailboxes located on Sabata Canyon Road, as well as on Avena Road where it intersects. This is the blind corner intersection. The bus comes twice a day and basically will coincide with the grow's start and stop times. Knowing a bit about this industry, unfortunately, many employees indulge in their product during their shifts. And high individuals, blind corner, and kids aren't going to mix. I did attach in my letter a photo showing where the school bus is on 2 locations, as well as a video, and how the bus has to kind of go off into the dirt because the road is so narrow. In conclusion, we strongly feel that this is not really compatible with our general welfare in this canyon. We fully foresee detrimental fallout, but thank you very much for being able to speak today.
Our next speaker will be Milton Johns, and I just want to say thank you for all of our speakers' patience as we go through with the hearing today.
Good afternoon, Commission. I'm very grateful for the opportunity to speak. I had a really late email submittal to staff, and I'm grateful to them for the opportunity to speak here at the 11th hour. I'm a resident of Sabata Canyon. I'm just west of the proposed facility, and I am also a former applicant for a large composting facility down in Orange County, where I had, as a principal of that operation, tried to mitigate the very same issues that I'm here to complain about today. I'm on the other side of the table, if you will. The problem that I was addressing in Orange County was that of the odor emissions attendant to a composting facility. And we, as a company, researched high and low mitigation measures that would address odor concerns of the nearby residences. And frankly, we were unable to come up with anything that really effectively addressed odor emissions. And my contention today is that the report that was done by FCS Engineering falls short in the same capacity. I'm sure the Commission has heard and maybe directly experienced the kind of odors that are coincidental with the operations of such facilities. The odors are profoundly noxious and really difficult to be around. The odors that I experienced at my residence due to unlicensed facilities were almost enough to drive me away. And I'm afraid that a facility of this size and of this intensity is going to make it just as bad, if not worse. And I'm very concerned that, again, SCS's engineering report that relies heavily on the Pennsylvania State Conservation Commission study, which we tried to rely on also, by the way, is great in theory, but in practice it simply will not work. And as a matter of fact, it's flawed in the way that it is structured. It's structured for livestock and poultry operations. Those operations agitate the soil that the animals are on. Airborne dust will, what's called adheres to the volatile compound. In their case, ammonia. In this case, with cannabis, it's a terpene. The vegetative barrier that's proposed will physically catch those particles in the Penn study, but volatile molecules are so much smaller, they're infinitesimally smaller, they'll pass right through a biobarrier like that. It would be like trying to catch a gnat with a butterfly net. So this biofilter planting dynamic is great in concept for agricultural facilities with livestock, but facilities that are horticulturally based, they have no application. So I would respectfully submit that study does not apply.
Thank you, Mr. Johns. Thank you.
All right, we're going to go back to Lee Johnson.
Hello, can you hear me?
Perfect.
Yes.
Okay, I apologize. I'm new at Zoom and I'm not the best public speaker. My name's Lee Johnson. We live directly northwest of Mr. Wolf, and we've been neighbors for 17 years, and we've always gotten along. And he explained the project a while ago, and we didn't really think it was going to be that bad until we got the document dumped last Wednesday and saw the plans and the hoop houses. And basically, I mean, the sheriffs could hire us and we could have a watchtower and watch over the whole property if they needed to be in compliance. We can see every part of the property. We've always given Mr. Wolf his privacy. I did notice last week I went for a run and somebody was watching me, and I don't know what that was about. And I stopped and I looked back and they were watching me and stopped. And it happened a couple times. And I have a daughter and we are concerned. And we don't know anything about the owners. I heard there was 3. There's a Ron guy that we don't know about him. I can usually do background searches on people, and I did on Herbal Angels down to every owner there was in the shell company on top of shell company, but I can't find anything on Tutron and Adrian Medina, and I don't know Ron's last name. And it is weird that we're going down this slippery slope of suspended LLCs and the nightmare that was Herbal Angels. And the land use thing is scary. How it goes on for perpetuity, I don't know. It's the business license that comes afterwards. And maybe that's something for legal action in the future, but it's just not the right procession of things to happen in this situation, because cannabis is in its infancy. They haven't proved themselves. They are technically mostly illicit. We have fears, and we've heard that mafia comes in, gangs come in and rob neighbors right before harvest. And then we're perched right up the hill in a nice house. We paid $30,000 a year in property tax. You know, it's nothing to sneeze at. I'm not saying we're Oprah or anything, but I just want you guys maybe to take that into consideration. I apologize if I'm not the best speaker. Thank you very much.
Thank you.
Our next speaker will be Dana Sicily.
Hi, thank you for letting me speak. I have a small indoor specialty medicinal indoor grow in Monterey County. I've been in the business since 2015, and I've had other people helping me, which were not trustworthy. Had a couple bumps in the road, and that's when I met Tran and his people that have come in and helped me with my grow and have turned it around completely. Two is very responsive to my company, any need that I have, being metric, track and trace. He is, just on it completely. And like I said, that, I'm very new to this. I had another partner that kind of left me high and dry. So he, definitely came in, gave me some knowledge, is very, productive for me, getting me to the next level of my state and my county licenses. And Ron he's for the grower part of it, he's the consultant and helping me with that as well. I've had no trouble with them. They're all very trustworthy, and they're whatever they say they're going to do, they do. Like I said, I'm a woman doing this, and they have been tremendously helpful and honest. As for their business, what I know about it, it's small. They're doing 10 acres of 100 to give a big buffer. They're only having 3 to 4 employees full time to keep down the traffic. I don't know the area, but from my experience with them, there's no, what the neighbor was saying, I have daughters myself. There's no thugs, there's no weirdness, there's no, mafia coming in. It's, I grow on my dad's property, it's indoor, but there's nothing funny, but there's no funny business and there's no thugs. It's a very professional business. And so that's what I can vouch. Ron and his group of people, they've been amazing to me. And so that's all I'd like to say. My experience has been wonderful. Thank you.
Thank you.
Our next speaker will be Laura Bonnet. Sent over ask to mute request. There we go.
Hello? Hi, I wasn't sure if you guys could hear me or not.
We can. Go ahead, Laura.
Okay. Well, good afternoon, commissioners. I did submit an email earlier, but I'll just go ahead and read what I had already written down. Good afternoon, commissioners. My name is Laura Bonet. I am the owner of the Greenhouse Collective. We are Santa Barbara County's first and only cannabis boutique. We are the only all-female dispensary in the whole Central Coast. I myself have been in the cannabis industry over 10 years. I co-own another dispensary in Northern California and a 180-acre outdoor cultivation facility in Calaveras County. My call today is in favor of New Era and Tua himself as well. We've been receiving their flower here for a while, and they provide a very high quality flower and an amazing price. They're one of our favorite for our patients here at the greenhouse. Tua and his team have been honest, trustworthy, professional, and the quality of products they have provided is outstanding every time. Our customers are always looking for local grown flowers, and we're excited about New Era opening a local cultivation site to provide high quality product grown right here in our own town. We are also very impressed with the care New Era has taken in designing their project to be a small scale project to fit within their neighbors. 10 acres in a big parcel like that is actually amazing. They have proposed a small grow on a large site. I believe New Era and Tua itself would be a great addition to the cannabis cultivation in Santa Barbara County. We're more than excited to welcome them. Tu and his team are great people who will be great neighbors, and I encourage you to approve the project. Myself and the greenhouse totally stand behind the project 100%. That's it. Thank you.
All right, our next speaker will be Mark Shatillo.
Well, good afternoon, members of the commission. I'm Mark Shatillo. I'm speaking to you today on behalf of the Santa Barbara Coalition for Responsible Cannabis. A number of issues I'd like to raise with this project. First concerns the project description, which and the number of harvests. You've heard staff or had the applicant and the project description say there's one harvest, but that conflicts with the odor abatement plan itself, which is also part of the approvals that your commission is giving. There's a lack of consistency and harmony. There's a reference to the operations plan in the odor abatement plan, which calls for these 2 harvests, and that should be brought forward. Secondly, this issue of Ecosorb, be it vaporized or atomized, that's a very significant difference. And what's provided to you is ambiguous in the odor plan as to what they're specifically calling for. I did look at the conditions of approval. The CUP is issued to New Era LLC, not to Mr. Tran. Turning to the conditions themselves dealing with odor, condition number 11 identifies the odor plan. The odor is required here as a conditional use permit requirement. It is needed to ensure compatibility with the surrounding land uses as part of the compatibility finding that you have for a conditional use permit. The odor plan itself is ambiguous and vague in several respects. It is inconsistent with condition number 1, the project description, and further, it's inadequate to ensure that there will not be odors. If you look carefully at the odor plan, it provides that the complaints that would trigger the additional review require that there be odor complaints from local residential receptors, vaguely likely to be interpreted as people within residentially zoned areas. So residents that are on agriculturally zoned areas may not qualify to be able to register as a complaint that would trigger the active corrective actions that are really an essential part of the odor plan. The coalition is willing to work with the applicant to refine the odor abatement plan, to develop the 4 critical elements: community notification, the odor technology, odor episode confirmation, and the corrective actions, each of which we find to be deficient in the proposed plan that's before you. Specifically, relying on vegetative buffers is an untested technology, and if it doesn't work, unfortunately, the way the plan is set up, there may be no way to remedy that problem. The staff and the applicant conflate the requirement under the Land Use Development Code that says that residential zones are where odors matter with the finding that you make as under the conditional use permit. And this is one of the key issues that I think your commission has to wrestle with. The neighborhood compatibility is not limited to residential zones. It's limited, it encompasses all of the people and uses that are within the neighborhood, and that would include residences that are not on residentially zoned land. And the whole staff report analysis, the findings and the conditions, and the odor plan are geared to address that misunderstanding, that misperception. So as a result, all of the approvals are inadequate to protect the surrounding neighbors. So we would ask that your commission direct the applicant to revise their odor abatement plan, conform it to the project description, work with the community to develop a workable solution for this project. As you've heard, there's a great amount of distrust and a lack of familiarity. And I think that's not an irreconcilable problem, but it does take some effort to do that. So in closing, we would ask that your commission defer action or deny the application and direct that there be additional outreach to the community and refinement of the odor plan. Thank you, Mr. Chair.
Thank you.
All right, we have 3 more speakers.
So Commissioner Park, you have a question for Mr. Chatilla?
I do.
There you go.
Mr. Chatilla, I'm going to be very specific. I know that on December 12th, we had the hearings on both CVW and CCA, and you were part and parcel of the effort to write the adaptive management plan provisions of the odor abatement plan for CVW. Isn't that correct?
Yes.
And those were termed at the time by Commissioner Cooney as the gold standard. And CCA, which was approved the same day, you were part and parcel of the effort to write the adaptive management plan provisions of the odor abatement plan there as well, correct?
Yes.
And that was referred to by Commissioner Briley at that time as the platinum standard. And when this CCA went on appeal to the Board of Supervisors, the board adopted certain other provisions, which you worked out with CCA on testing that were added to these adaptive management plan provisions, correct?
That's correct.
Okay. So you are familiar with adaptive management plan provisions for these projects. Are those provisions, because I'm looking for consistency, are they in these conditions of approval for this project?
No, I do not find them there.
Okay, thank you. Oh, what's missing?
Well, the 4 elements. First, community engagement, where you notify and you educate your neighbors so that they're actively involved. They know when harvests are going to happen, when you're going to have odorous periods. Just a good neighbor mechanism. That's the first piece. Second, odor technology, relying on vegetative buffers, I think it is an untested technology. What's missing is the testing to confirm. If that worked, boy, that'd be great. That would solve a lot of problems. I'm pretty skeptical that the Pennsylvania study is going to do anything for cannabis odors. Different source, not terpenes. So second, odor technology is not adequate. Third, odor episode confirmation is very vaguely identified, and as I noted in my comments, limited to residential zones. And then lastly, the corrective actions are also limited, and the triggers and the implementation of those corrective actions could lead to polysorbate 80 being atomized into the community. That's not something that anybody wants to breathe. You can eat it in your ice cream, but you don't want to breathe it in the air. So all 4 pieces need to be strengthened, in my opinion.
Thank you.
All right, our next speaker will be Renee O'Neill.
Good afternoon. Can you hear me?
Yes.
I don't even know where to begin. This project appears to be no different than the illegal Herbal Angels LLC turned out to be. Will you, commissioners, once again discover too late and find out that it was like waking up to find that your new bride was a serial killer? What is Ron's last name? Why won't anyone provide his last name or speak it? That should be a red flag. The permits that run with the land are inappropriate for cannabis. It's unbelievable to me that someone that may be a legitimate or illegitimate LLC can simply fly through the motions of getting this land to qualify and then all of a sudden flip that permit to someone else. It makes no sense. The neighborhood compatibility is non-existent. The county has utterly failed to protect the EDRNs. We're not protected from illicit industry growers that still operate in both our Tepesquay Canyon and Sabata Canyon. There's escalation in traffic. There's escalation in criminal activity. And regarding the Monterey residents' comment on thugs and cartels not being a problem in her area, well, come on down to Tepesquay, honey. You don't have a clue what goes on in our isolated rural neighborhood that is far from first responders. And we've seen nothing but an increase in criminal activity. Lee Johnson, I feel really sorry for you that you live right across the road, basically, from this grow site. I lived a half a mile from the grower that was shut down up here, and the 630 feet from a pot farm is nothing. And I agree. The comments that are made about what traffic they propose for this amount of acreage is ludicrous. They can be saying everything that they're saying, but I don't buy it, and I won't buy it. We see what goes on in our community with the person that's still operating out here, and and nothing that they say to the planner and is provided is truthful. Very little of it, let's just put it that way. So, Commissioner Park, in the previous item, you commented that one thing you don't like to see is people that are filing permits and then they get notice of violation and then they don't shut down their operation until they get into compliance. Then I would ask you, why aren't you doing anything about the Tepesquay grower that is operating on the 2 U.S. Forest inholding lands out here, who has multiple violations on his record and has from the get-go and has never stopped growing? That's all I have to say.
Mr. Chair, we have one last speaker who's joining us via telephone. So if you are here to provide public comment, you're calling in via telephone, you may have to hit *6 on your phone to unmute yourself. Again, if you're here for public comment and you're connecting to the meeting via your phone, hit *6 on your phone to unmute yourself. Mr. Chair, I'm not receiving any sort of response.
Okay. Well, we can move on. If they catch up to you later, let me know. Mr. Robertson, are you available?
Mr. Chair, yes, I'm here.
Okay. Hey, I had a question earlier. One of the public commenters was talking about a bus stop up on Sabata Canyon being located next to a blind corner with not enough room to be safe for the children. I don't know. I think regardless of cannabis going in or not, do you know anything about that? Have you received any complaints, or is there some way you could look into it to just make sure from the county standpoint that it is a safe bus stop or it needs improvements?
Mr. Chair, members of the commission. So the last time I had heard this issue was at the Herbal Angels hearing. It was brought up. Some pictures were shared and it did look congested. Nothing unusual that we would expect that from a rural bus stop, everybody coming to one spot. Going back to your question, have we received complaints? To my knowledge, and I can check with my supervisor and the other traffic engineer, but to my knowledge, we have not received complaints about this being an unsafe situation, other than the fact that it came up at the Herbal Angels hearing. And then to your question after that, can we look into it and see if this is something that needs to be corrected? Absolutely. After this hearing, I'll go over and I'll ask our traffic engineers if it's something that they can dive into and make sure that it is a safe situation.
Okay, that's great. Yeah, regardless of this hearing, I appreciate it, Mr. Robertson. Thank you.
No problem.
Commissioner Blau?
Yeah, Mr. Robertson, I have a question for you. I'm very familiar, as you know, with the traffic mitigation fees for commercial projects, industrial projects, that sort of thing. I have no clue what the traffic mitigation fees are for a cannabis grow. Can you help me there?
Mr. Chair, Commissioner Blau. So this is really tricky because, I'm going to echo the concern that the public speakers have made, that I am not thoroughly convinced that the project descriptions are matching the activities on site. However, I have also been told that the project description is the project description, and if the grower violates the project description, then it becomes a violation and it can be looked into there. So what I have been relying on is simply the trip generation estimates that are provided by the applicant. The odd thing about cannabis operations is that they tend to avoid the peak hours very conveniently. The shifts either end prior to the PM peak hour, they start before the AM peak hour, and generally a cannabis grow does not create the traditional AM or PM peak hour trips, specifically the PM trips that we would apply mitigation fees to. So it's rather difficult. The fees out there, they're really low. We really don't have a lot of infrastructure that we're building out there. So I don't feel that we're missing the opportunity for an infrastructure improvement, but I don't know if we're capturing the true peak hour impact.
Okay, well, one of the reasons I bring this up, and I'm not sure who does it, whether it's Mr. Wilson, Mrs. Plowman, you, your director, or whoever, but we're hearing a constant complaint about the road condition for Sabata Canyon and other rural kind of roads where you typically find cannabis grown. So I'm wondering if it isn't appropriate to ask the board to focus on an issue and say, look, there needs to be a different traffic mitigation fee for cannabis operations for all the reasons you just described and all the complaints we've heard for the past 3 or 4 years. And I could very easily see where the cannabis growers would not have an issue if they were to pay some additional fees for traffic mitigation fees, and for the board to direct those fees on roadways that service the cannabis operations. It could easily solve the problem of inadequate roads that we've heard complaints from everybody. It's like no one disagrees that road is unsafe or inadequate right now, other than maybe the highway patrol says it's standard, but even I can't believe. I mean, those roads are inadequate. Now, the fact that they were rural 10, 15, 20 years ago is a little different than what the roads are being used for today. Is there any mechanism that you know or what we should be doing to further that?
So, Mr. Chair, Commissioner Blau, I think we need to take a step back here, and I don't believe the department agrees that the road is inadequate, because as it was brought up earlier, if we were talking about, I think Commissioner Bridley said a cherimoya grower or strawberry grower, or you name any other type of agricultural use back in that canyon, we would not be having a debate on whether the road is, quote, unsafe. So it makes us look at what metrics does the county have. I mean, we're talking about roads that are built prior to engineering design standards, and I'll touch on that in just a second. But if our only metric is collision history, and I have run the collision data on this road, there over the past 3 years, which is our standard, we've had one collision on the road. That one collision was with a deer that crossed the road. So it had nothing to do with unsafe speeds or drunk drivers or inebriated drivers, then the comment is always made, well, there's lots of near misses. So you're just not seeing, or you're not collecting the data for what's going on out there. Well, that may be the case, but that's the case for every road in the entire county. So our only metric is documented collision history from the highway patrolman. And there is no collision history pattern on that roadway. We don't receive complaints other than when the cannabis projects come forward. That alone tells us that the people are fine with the roadway until a cannabis grow comes in. So what I'm seeing is that, and at no fault to the residents of that roadway, but our belief is that just like any other project, traffic tends to be pinned on as the bad guy, that's how we stop a project. And taking a step back from this department and just saying, this is an agricultural use. If you were talking about another ag use, we wouldn't be having the same conversation. I don't see what we can do. I really have no nexus for anything. On top of that, we've had this discussion on Ballard Canyon Road. If you want to do something and put money into a mitigation fund or do a capital improvement, the residents generally don't want us bringing a road up to county standards because it smooths the curves out. It provides more roadway space, which allows people to drive faster, which in theory, they claim makes the road unsafe. So it kind of puts Public Works in a lose-lose situation here. I really don't know what to do for the residents. I'm sympathetic, but I'm still going to fall back on my comment earlier. Based on the metrics that we have, we do not feel that that is an unsafe roadway.
Well, okay, and I think that's an appropriate response. However, I don't like the idea that we don't make a change or improve the road till somebody dies. I think that's the wrong way to look at things. We've had so much testimony over the past 4 or 5 years about some of these roadways, and people bring photographs and, trucks across the line or trucks where there's not enough shoulder. That I'm sorry, that bothers me. I can't sit back and wait till they kill 3 kids on bicycles. Now we'll fix the road. That doesn't make sense to me whatsoever. Now, and also, I don't want to be the one that's approving projects that's going to put those people in danger. So now the board is the one that get elected. If we take to them the fact that we've had all this testimony, it's unsafe, and they say, okay, we're not going to do anything about it, that's great. But I have a problem with that. I've heard too much about it to say that it's unsafe, or I can't sit back and do nothing. I've at least got to say to you and to the board, it needs to be looked at, it needs to be addressed. Although it doesn't meet your metrics, it meets mine. If I drove the road myself or I talk to people that live out there, it's not safe.
Yeah, Mr. Chair, Commissioner Blau. And I don't disagree with you. Maybe something does need to be done, but for this project, I mean, we have what it is. The metrics are there. We have government code, which defines what an unsafe roadway or an unsafe situation is. And from a legal standpoint, it does not meet the legal standard for an unsafe condition. However, going one step further to what you said, we do have a process, and this process for some reason is underutilized by most of the county residents. Every year, Public Works does the roadmap process where the public can come in and bring up the concerns that they have in their neighborhoods, projects that they want to be added to the roadmap. And that is the appropriate mechanism for this neighborhood to come forward, voice their concerns about their roadways and what improvements they would like to see done to their road so it could be added as a capital improvement and taken care of if the county chooses to do so, since that is adopted by the board.
Thank you. I agree with you. This is not I can't deny this project as a result of the road condition, but I do want to listen to people that feel that the road is unsafe and make arrangements to try to make it safer. So I think we're in agreement. I just want people, I'm glad that we agree, and I just want people to understand that that's what needs to be done.
Agreed. And Mr. Chair, Commissioner Blau, again, I'm going to reiterate the fact that if a community feels that there is an issue with their roadways, the appropriate mechanism is to come to the roadmap meetings and voice their concerns there, because that's where upper management hears the concerns, and things can be done that really can't be done or shouldn't be done on a project by project basis.
Very good. Thank you, Mr. Robertson.
You're welcome.
Commissioner Bridley, your hand was up. No more. Commissioner Park.
Yes, Mr. Robertson, you still there?
I am still here. Yes.
Oh, great. Thanks. You know, it's funny because I've been looking at this road for Herbal Angels, this one and all that. Now I'm kind of confused by what we mean by the road because, you know, I turn off the highway and there's a 2-lane paved road that goes up and then it stops. And then a much narrower, rougher dirt road goes up and it goes to this project and goes beyond that. When you're referring to the road, are you referring to the paved part? Are you referring to the whole thing? What are you referring to?
Chair, Commissioner Park. So I think there's two answers to your question here. So from a development review standpoint, my primary lens is the road fronting the project parcel, which would be the private road, the dirt road in what you're referring to. However, access is taken from the paved road, and I think the community is referring to the paved road portion that's going to accept the additional traffic from the project. So I think that's what you're looking for,
So
but
the
I mean,
paved road is part of what I'm looking for. And so the paved road is a public road, right?
correct. So then I think where you're going with
But
this
then
is,
when we get onto that,
go ahead.
well, is the dirt road, is that a public road or a private road?
That is a private road. Where the pavement ends, give or take,
Okay,
with a couple hundred feet, is the end of the public road.
All right. So, but then the road that continues on, that's private road.
That is correct. There's a private easement.
Yeah. Okay. And you don't maintain that, right?
That is correct.
County doesn't maintain that.
We maintain
Okay,
up to
so
where the
it's-
current pavement ends.
Right. And that private road, it's built to different standards, is it not? It's narrower, it's rougher.
Yeah, I mean, it depends. So at that point, the fire department standards for either a driveway or a private road, I'm not sure how many residents it actually supports, but the overall jurisdiction falls into the fire department once it leaves the county right of way. And you are correct. It does get built to a different standard.
Right. I mean, I notice when I'm driving up there, sometimes I have to pull aside so somebody else can come through in the other direction, which is certainly not the case down where on the public road.
Right.
Okay,
I mean,
thank you, Mr.
and
Robertson.
really quick, I just want to add, keep in mind that a lot of these roads that we're talking in the ag parcels were built well before the engineering design standards were even adopted by the Board of Supervisors.
Right.
So that's why we see the narrow roads, and that's where we fall back on the collision history kind of dictating whether or not we feel that it's an unsafe road or an unsafe situation, simply because just the sheer cost to bring a road that was built well before the design standards, to bring that up to standards, it would be cost prohibitive. We already have a hard time maintaining our current road inventory, let alone upgrading every road to the current engineering standards.
But once we get up on that private road, we don't have a history of a lot of use, really, do we?
I would say that's probably a fair statement.
Yeah. Except though I understand it's part of the old wagon road to Los Alamos, so maybe we can look back at that. That's probably before your time. Thank you.
No problem. Thank you.
And before my time, but maybe not Chairman, maybe not Mr. Blouse, I don't know.
I was going to say that. Not Mr. Blau.
So thank you very much.
All right. And Mr. Villalobos, caller number 4 never connected. So is that correct?
Oh,
Mr. Chair, that is correct.
Okay, we'll go ahead and close public testimony now, and then move back to the applicant. Would you like to take a few minutes to?
Thank you, Chairman Farini and Commissioners. I'll just respond to a few of the points that were raised in the public comment. Regarding the nursery, that is only for developing the baby plants for use on the New Era site. There's not going to be any clones sold. So the nursery would be used 1 or 2 months a year in the springtime to get the little baby plants going, which can then be moved to the cultivation areas on the New Era site. It's not a part of the property that will be active most of the year. And we would be happy to revise the project description to more explicitly spell out how the nursery is used, if that's desirable. Second, the number of harvests it's 1 harvest a year. Like a lot of these projects, as they move through the process, there's some evolution in what's proposed. And early on, there were 2 harvests proposed, but the project description as it stands is for 1 harvest per year. Regarding the number of employees on site, people that are thinking that, maybe we've underestimated that number. We wonder if they're thinking about a kind of a standard operation that has 3 harvests a year, or are thinking about sites that have processing or manufacturing on site and require more people. Our applicants are confident that they can operate the site with the maximum of 5 full-time employees and just their 1 harvest per year. And of course, that's a part of the project description that the condition compliance staff of the county will be taking a look at when they come out on the site to see if everything's operating as per the project description. If they see that there's 12 employees out there, that's going to be a red flag that we're not doing the project description. So that's a pretty easily enforceable component. Finally, regarding the OAP and the adaptive management plan component of it, each of these odor consultants writes up their OAPs using a little bit different wording. We're familiar with OAPs that are written by SCS engineers, by Nate Seward, by York Engineering, and we've written them ourselves in-house at Flowers and Associates here before, and then we've seen OAPs written by kind of in tandem between applicants and community groups. And so the exact wording of how an adaptive management plan is spelled out, I've seen it written many different ways. And it is our intention that this is an adaptive management plan that includes monitoring and logging and reporting, and if there are continued problems, solutions that are acceptable to planning and development, including a buyer system. And we're totally willing to accept a condition to clarify the wording in the OAP or add some wording if it's not clear enough. And I think that's it for now. Thank you very much.
Do you have more, Commissioner Park?
I do of Mr. Peterson. I'm very familiar with hoop houses from the, do we have 8 hearings on the hoop house ordinance? And of course, visiting different properties and how they benefit different kinds of crops. But cannabis is a little different. And with cannabis, I generally hear about it for protecting the crop from drift of pesticides and whatnot. But why do you need hoops on this property? What's the reason for the hoop houses?
Chairman Farini and Commissioner Park, my understanding is that the use of hoop houses is beneficial for protecting the crops from the elements, the rain and the wind, and Also, I've heard that it can contain odors to some extent. When you're operating in a hoop house, it's more of a contained environment that's a little more controlled than being out in nature. So that's why they have proposed using them on this site. But the applicants have indicated to me that if the use of hoop houses are a big issue here, that they would be willing to remove the hoop houses, perhaps on the upper grow area that's closest to the Johnson property to improve their view. We're not married to the hoop houses, if that's an important point for neighborhood compatibility.
Thank you.
You're welcome.
I had a couple of questions. When I was on the site visit with you, there were some remaining rows of citrus trees, and I had asked if there was a way to maintain those on site wherever possible on the perimeters of the grow. I thought that would be a kind of a good biological catch for any odors, and then plus just the natural aroma of the citrus. Were you able to consider that anymore?
Chairman Farini, yes, we'd be willing to maintain the citrus rows that were there. I think when we were walking around on the site that day, you were specifically looking at what number is that area? I know exactly the cultivation area that we were looking at, and there are 2 rows of existing citrus trees we're planning to maintain in front of that. Behind that, there are some citrus trees that would be replaced with the cannabis. But those first 2 rows, what's the cultivation area number of that area he's talking about? Okay. Let me just get my map open to the cultivation area number. Looking at the map here. Okay, I'm getting to the page right here. There we go. Okay. Cultivation area 2 is the area that we were walking around, and as you can see on the plan sheet, if you look at, I think on sheet 1 of the plan set, it numbers the cultivation areas. Wow, I even have it circled right here where you and I talked about it out on the site. On the west side front of cultivation area 2, there's 2 or 3 rows of existing citrus that would be retained.
Okay, very good. Thank you.
Thank you.
No further questions of the applicant? Okay.
Chair
Let's.
Farini,
Yes.
Chair Farini and Commissioners, if I may, if now's the right time or if in a little bit, but staff just wanted to clarify a few items for the commission that were brought up in public comment and some of the back and forth, if now's a good time.
You were next on the list, so perfect timing. Thank you.
Great, thank you. So I have a little list here regarding some of the public comments about bio. Staff just wanted to note that the applicant prepared a bio report, and it was peer-reviewed thoroughly by the county's technical consultants. Regarding the concerns about the number of employees during the operation, to add on to what Mr. Peterson said, The operator and the operation plan is evaluated at the business license level, and planning and development does have a role in reviewing those applications to ensure consistency with our land use entitlement.
Can we get a little closer to the microphone, a little louder, please?
Sure thing. Planning and development does review business license to ensure that the business license process is it conforms to the land use entitlement, and part of that review is the number of employees that are proposed as part of the operation. So for example, if the land use entitlement identifies a total of 10 employees and the business license says 15, that doesn't align with the land use entitlement and will need to be reevaluated. So just wanted to clarify that. Regarding the odor abatement plan, because this land use entitlement is a conditional use permit, there is the odor abatement plan requirement. The land use and development code does require prevention or minimization of odors as experienced from residential zones. So just to clarify that, the nearest residential zone is about 750 feet south of the project site. So while there are closer residences, these are on ag zoned parcels. Composting was brought up as an issue, and potential odors emanating from composting. As part of the OAP requirements, the plan is supposed to identify odor producing activities. Composting was addressed in the OAP. However, it's noted that there is very minimal odors that arise, and it is our understanding that for whatever gets composted basically has to be made unrecognizable and unusable. So that means that it is basically combined with other organic matter to really help with that composting process. And I believe that is it on my list. Please let me know if anybody has any questions or requires additional clarification. Thank you.
Okay, thank you. Okay, Commissioner Cooney.
Thank you, Mr. Chair. Ms. Lair's presentation has raised one of the issues I'm concerned about, and that is the ordinance, which is the starting point for our review of these projects, appears to speak of residential zones and not residences. That's some time ago, and I can't recall a lot of discussion about the difference, but the way Ms. Lair just explained it, it seems that you could be surrounded by agricultural residences of different sizes, and it wouldn't matter. The odor abatement is triggered by exposure in residential zones. And I just want to confirm what I think is a critical problem with our ordinance. Is it staff's position that that's the interpretation, that it's residential zones and it's unrelated to the number of residences and therefore people in the residences?
Commissioner Cooney, through the chair, I'll start with that, and then I'll let Ms. Lair and Mr. Seawards clean up after me. Looking at the odor abatement plan requirements in section 3542.075 of the ordinance, it outlines the requirements for odor abatement plans. And one of the statements in there is the odor abatement plan must prevent odors from being experienced within residential zones as determined by the director. So Ms. Lair was correct or accurate when articulated the difference that was brought up by the public comment as far as residences in the area and what is required by ordinance in the odor abatement plan requirements. However, on this particular case, because it's a conditional use permit, the commission does have broader discretion because there is a finding on conditional use permits about neighborhood compatibility, which, as we've discussed before, isn't a finding for land use permits. So there's a little bit of a distinction between those two different concepts that was brought up by public comment. So the odor abatement plan, there is no requirement that the odors aren't experienced by residences. It's residential zones in the ordinance. And I'll let Ms. Lair or Mr. Seawards add anything to that if they would like.
Nothing to add.
Yeah, staff has nothing else to add. Thank you, Mr. Wilson.
Mr. Chair, may I respond?
Oh, yes, please.
Okay, so if what I understand Mr. Wilson to say is this commission could condition the odor abatement plan to apply to residences on agricultural land as a condition here. If our finding and concern is that we would like to protect people living in the vicinity of the cannabis operation. I just want to be sure about that because that would make a difference to me knowing that area is basically residentially zoned outside the EDRN.
So is staff concurring with Commissioner Cooney?
I think staff would say that the commission has discretion to put any conditions on a project that would create a stronger link to neighborhood compatibility. So if you wanted to add conditions or amend conditions to address neighborhood compatibility, you would want to look at it through that lens. So
thank you, Mr. Stewart.
Yeah.
Mr. Wilson?
Yeah, Mr. Chair and Commissioner Cooney, I would direct the commission to look at the findings required for conditional use permits to supplement what Commissioner Cooney was talking about in section 3582.060. It refers to findings required for all conditional use permits. And the finding, there's a couple of findings there. Finding E talks about the proposed project will not be detrimental to the comfort, convenience, general welfare, health, safety of the neighborhood, and will be compatible with surrounding areas. So that gives the Planning Commission a little bit more discretion in regards to evaluating a project and making the findings. So as the commission considers or deliberates on this project and on this finding, if there was a condition that was needed in order to help the commission make this finding, then that would be something they could you could use your discretion in developing or seeking assistance from staff.
Great. Any other questions by the commission? Okay, let's move on to deliberations then, discussion. Commissioner Bridley or Commissioner Park. There we go.
Somebody's got to start, right?
Yeah.
I can start.
Did you ever decide who?
Oh, let's let Commissioner Bridley start.
I'll warm it up
Okay.
for Commissioner Park. How about that?
There you go.
Okay. Really good discussion today, and I'm very appreciative of everyone's comments and questions. I think that as much as I had concerns about the other project in Sabata Canyon, I really don't have a lot of concerns about this one. If the commission wants to move ahead with some sort of strengthening of the odor abatement plan, I believe this applicant is probably willing to work that way. I understood from my site visit that they had reached out to many neighbors and were actually not successful in getting calls back from most of them. So in going up this canyon, again, this is an ag zone. And Commissioner Farini Brown acted with Commissioner Parks, so I couldn't drill him on being an ag professional. But ag is messy, ag is smelly. They have a wonderful neighborhood there that they've kind of transformed into an equestrian-centric location, but anybody could come in onto this farm and plant garlic. It may not make sense, economically, but it would be a lot smellier than what's out there now. And the fact that this is just like so many ag properties in the county, it's a citrus and avocado ranch in decline. We see them all over the place. So if this is going to be 10% of the land area into cannabis, with an applicant that is trying to do as much as he can in terms of keeping some of the existing crops, locating in a concave geography that I think is going to be buffered from everybody else down the canyon, I am willing to go with it. The additional tangential issues like traffic safety, like people being killed on the road, is a complete and utter red herring. If that's really what we want to, degrade to, then we can actually look at probably 80% of the roads in this county and have the same conversation. We are a county of rural roads that aren't maintained because we don't have the money to do it. So what Mr. Robertson said about in the last 3 years having one collision report, that's the standard. That's the standard of engineering, and just because we all drive doesn't mean we understand traffic engineering safety. So I don't think there's an issue with traffic safety at all. I also don't think there's an issue with fire safety because the county fire marshal has already looked at this and said it's okay. So, at some point we sort of have to get over the hump of these tangential ancillary issues and focus on what's really key to our findings. The CUP is a tough finding, the one that Mr. Wilson just pointed out, the neighborhood compatibility. And if getting a stronger odor abatement plan to try to address what we're hearing from some of the neighbors, I'm okay with that. But other than that, it's an ag property. It's an ag property. It's an ag property. And I would support the case. I probably have much more to say, but I'm going to shut up because you guys don't want to hear it. It's okay. Thank you.
Commissioner Park, I'd like to go next because of what Commissioner Bradley said, if you don't mind.
I don't mind at all.
Okay. So as the dirty, messy farmer, right? That it's interesting when I go look at these projects and it's all Ag 2 100 property up there. And the Johnsons have built a beautiful home on a beautiful ag property, right? And I get that. It's like, if I had my house up there, I wouldn't want anybody coming around smelling up my neighborhood. But that's what farming does. It makes noise. It brings in a lot of people. And comparatively, yeah, if we put raspberries up there, okay, just on a little, well, for one, we'd probably be able to grow a lot more than the 10 acres or 11 acres going in. And we'd have 2 to 3 people per acre on that property. And we'd be using more water. We'd have hoops. It'd be noisy and it'd be messy, and we would not make a good urban neighbor. It doesn't work. So from going up there from that perspective and then looking at what this applicant is trying to do, and it's still technically ag as we've been told, it's like it's hard for me to get very restrictive. That doesn't mean that's right. It's just that's kind of where I come from looking at it. I did ask my supervisor's office to look up for me what the buffer distance is for a school. And in this case, it's 600 feet is what I was told that the state requires. They use property lines for the state one, but for this project, I would ask that the applicant respect a 600-foot buffer from the from specifically the Johnson's house, so that no cannabis activity occur within 600 feet of that home. That gives them more protection than it would be normal, according to our ordinance, but I think it's worth it there. As far as hoop houses on the grow directly next to the Johnsons, I measured it on Google Earth. It's 650 feet. I'd like to see no hoop houses on that one. There again, this is just a courtesy ask. The commission may choose to make it harder, or more stringent, or a rule or whatever. But there again, try to protect some of that for them. I feel that this applicant wants to get along, so that would be my suggestion. It would go a long way to getting along. Everything else about the project, I like, and I would support. The traffic thing, yeah, I agree with Commissioner Bridley. I think she worked through all of that better than I could restate. So those would be my asks, and I see a problem here. Commissioner Park.
We have some divergences of opinion here. I spend a lot of time touring cannabis sites, ones that have been approved, ones that are prospective, ones that haven't even been worked out yet as being cannabis sites, where people will ask, what do you think about this? And I can't name another single cannabis site where it's served by a single lane dirt road shared by other people, and it's the only way out. So you may dismiss those traffic concerns, but I think you got to look at what's on the ground and think it through. And in my opinion, they're legitimate. I think it's also fallacious for us to compare every cannabis project with other agriculture and say, well, see, it's not any worse than anything else. But you know what? We're not supposed to regulate strawberries and blueberries and broccoli and so forth. It's not in front of us. We are supposed to regulate cannabis. That's what the ordinance says. And cannabis involves much, much larger amounts of money, and it kind of warps things a little bit different. And I think we are asked to make a finding of compatibility for a CUP, and this is a CUP project. And that means that we do look at things without comparing it to every other form of agriculture and what could be worse. Oh yeah, I mean, I could grow potatoes there and silage pits and all the stuff we used to do in Idaho and make it really bad, but that's not the question. Now, but getting back to the project itself, one, I really appreciate the efforts of the planners for the project to minimize the impact. I think that they've been very modest about that, because there's only so much time in a day to go through a project, but they've done so many little things to make this work better. And they're really good at it, because I've seen them do this at other projects. And Mr. Peterson knows I'm mad at him, but he knows I'm mad at him because he left the county, and I wish he was still at the county. But they've really worked hard, and I appreciate that. I still have some concerns, and I'll express what they are. The hoops will be extremely visible from the Johnsons. There's not really a reason to need those hoops. I would eliminate them everywhere. You don't need them. Well, you need them I think in the nursery. The nursery is much larger than it needs to be. It just happens to be that's the size of the field. I don't like field number 4. I would eliminate it because it's too close to the Johnsons. Maybe it needs to be, some of its production needs to be moved somewhere else. I don't know. There's still plenty of cannabis grow without it. I think we should be standardizing our treatment of conditions for CUP projects for all cannabis projects. And that's why I keep bringing up platinum standards and gold standards and all those kinds of things, because I really don't understand why we would take a very prominent local grower like they have at CCA and impose standards on them and not impose them on people we barely know in a neighborhood which is has much more problems with traffic and other things. I don't get that. I don't see why we should wander all over the map. We should standardize this, and we should standardize the adaptive management plan provisions, and they're missing here. One final thing is that, I've personally expressed several times my desire that these permits be restricted in time, because as it stands now, they'll outlast the pyramids and the sequoia trees and everything else. They're forever. They're the only thing in the world that is forever, except for death and taxes, I guess. I don't know how that goes. But when we look at a CUP and we make that finding of compatibility, I think we do have to look at what the neighbors are going to live with. And the neighbors here are very, very uncertain. They're disturbed because they don't really understand who this operator is, what's going on with New Era, who are the people behind this, what's going on there. And that disturbs me as well, because in most of my work with the cannabis industry, they're falling all over themselves to introduce me to the owners and to show how local they are and how connected they are and all the good things they do. And this remains sort of a mystery. Maybe that's just a problem at Sabata Canyon that does that. I don't know. So looking at it overall, if I had to vote today, I could not make the compatibility finding and I could not support the project. Thank you.
Mr. Chair? Oh, you're muted.
I think everybody is.
Okay. Yes, Director Plowman.
I just wanted to make one remark about a comment that Commissioner Park made, and that related to this adaptive management concept that's been evolving through work between the landowners or growers and the coalition. And the reason we don't have those in every permit is because they're not in our ordinance. And so that's not something we can mandate. If they want to work out an agreement and they want to include those in the odor abatement plan, then we are supportive of that. But that's why the Planning Commission is not seeing those elements in every odor abatement plan that comes before them.
Commissioner Park.
You know, I get that, but I don't think it goes far enough. We can mandate it at the Planning Commission as a condition in order to meet that compatibility requirement. And that's just what we did in CCA. So I think what Director Plowman says is exactly true, but it doesn't go far enough. Yes, we can mandate it right here and now in order to standardize how this is treated. And we can do that in order to meet the finding of compatibility, or else we just deny the project, say, no, it's not compatible. But if you do X, then we can find it's compatible.
Mr. Chair, Commissioner Park, that I agree with that statement. I was just remarking on why you're not seeing them built into the project when they come to you. But if the commission has conditions they need to add in order to find compatibility, that is where you have your latitude.
Okay, Commissioner Blau.
Yeah, I'm going to agree with Commissioner Brady and Commissioner Freeney and finding an approval for the project. So I don't know where you want to go from here, but I guess it's Commissioner Park's district, so he has the privilege of making the first motion. I don't know if he wants to make the motion for denial and let it lose in a 3-2 vote, or just allow Commissioner Pretty to make the motion to approve the project. But I'm agreeing with Commissioner Farini. You know, I live in Santa Maria, so I'm probably exposed more to the ag smells than maybe our South County commissioners. You want a really terrible one? Go do sugar beets. I got a tour one time of the Betteravia sugar beets processing plant. I'm going like, are you kidding me? That's probably, I mean, it was so bad. After about a half an hour, I said to my wife, said, Peggy, I got to leave. If I don't leave, I'm going to lose it. I'm going to lose lunch here. So, you know, I get it. It is an egg operation. I'm sorry. And it's not the worst egg operation. The worst one I ever had was sugar beets. That was unbelievable how they could work out there. So it is an egg operation. I feel sorry for anybody that builds their resident house next to an egg operation, but that's why we have zoning. And, you know, if you want to live there, there's some wonderful benefits. You live next to a winery, it's fabulous. Next to sugar beets, not so good. That's my position.
Thank you, Commissioner Blau. Commissioner Cooney.
Yes, thank you, Mr. Chair. As the consensus is forming here, I'll just state why I'm uncomfortable voting today. I don't go all the way as far as Commissioner Park might go in terms of mandating standardization, but I look past that to each project, and I think we're charged with going project by project, and there are differences. This is North County, and CDW was Carpinteria, and there are real differences in the relationship between residences and cannabis operations. So I think it would be nice if we had standardization. What I think Commissioner Park and I would agree on is that we ought to shoot for the highest possible project in terms of compatibility that we can possibly get. And here, I don't think we've done it yet. My view is we could. I think that odor abatement plan can be tweaked to build in more interaction with the public. Some of the other conditions that are very valuable in the best projects we've seen do involve the surrounding community and the real effort to be successful in controlling odor. Here we are, 3 years into these reviews now, and we still are putting our hands up and saying, well, the odors aren't any worse than sugar beets, or they aren't any worse than Commissioner Bridley used poor garlic as an example. The Italian restaurant downstairs from my office has lots of garlic, and I can live with that. But I think we have a higher responsibility to the community for cannabis. So I would vote against the project today. I think this applicant is sincere in trying to be compatible with the community. I'd like to give them a chance to upgrade their odor abatement plan to incorporate more protections so that we don't have to send this on down the road and say that's the best we could do.
Okay, thank you, Commissioner Cooney. Commissioner Bridley.
We heard some really good improvement ideas from Commissioner Park and Commissioner Farini today, Chairman Farini, excuse me. So I'm wondering if the applicant would consider possibly looking at their project description and their map, their grow areas, the retention of some of the citrus areas that Chairman Farini pointed out, thinking again about the odor abatement plan, since what I'm hearing from the commission is an emphasis on community outreach and some sort of adaptive management with the neighborhood. Because I would be delighted to make a continuance motion to see what they come back with. If we, just out of respect for what I'm hearing from the other commissioners. So is there a way, is this appropriate for us to ask if the applicant would be willing to consider a continuance, or do I have to make that motion and then see how it goes?
So tagging along on that, right, is if you deny the project, did they start over, or isn't it more constructive for us to come up with what the solutions are and guide them to come back with those solutions? And Commissioner Park, I'm looking to you on that as well. Is it just no matter what, or are we getting on the right path with you to come up with a way to get this project through? I'm not sure. Tell us.
You know, I'll be a little philosophical about this. I always think that a good consensus from the commission is something we should try to attain. I think it sends a powerful message to everybody, and it's better for the project, because frankly, you don't want to squeak by with a 3-2 vote and then get appealed and then go to court. What you want is a 5-0 vote, and then you do much better on the appeal to the board, and then it's much harder to kick it out in court. I mean, that's just the truth of it. And I think if we can work out a project that works better for the neighbors, but also for the applicant, it's worth doing for everyone's sake. And I think that, like I said, I really think the planners for this project are excellent. I think that they have done the very best they could think of to mold this project so it works. And I think they're open to other ideas. I think probably a continuance so that we could do that and get them a consensus vote is a good thing for them, and it's good for the neighbors. And the neighbors probably ought to read the tea leaves and hear that if this was a vote today right on the project, it would not be stopped. So I think that the neighbors should understand that this is a worthwhile endeavor to continue this, work in some of these improvements, and then beyond. I'm going to venture a little further. What people kind of need to think about, and it's about a canyon. And I've told a lot of people this, so I'm not inventing something now that's not confidential. And that is, do you think you can hold off every single project? Or do you think maybe accept some of the more benign ones, or 2 or whatever, and that might, in a sense, prevent some of the worst ones from coming in? So it's these are all just important things. So I think that I would support the idea of a continuance so that we could work out some of these things. Does that answer your question, Chair Fringy?
We're getting there.
Or am I just wandering?
And I know you're a lawyer, you get paid by the word, so it's going to take a few more words. So Commissioner Park, do we come up with a punch list today, or do we just redirect staff and the applicant based on what we've discussed today and let them come up with the solutions? How hard do we hold the reins?
I'll weigh in for a second, Commissioner Freeney.
Let me just finish this real quick.
Okay.
Real quick. Commissioner Park.
Okay. I think that it's a good idea, as you call it, a punch list, to identify some things that could use some work. And I don't know if staff needs that or not, but I think they'd appreciate knowing about it. And I think that the planners for the applicant would surely like that. You know, they want to work hard on this. They don't want to make a mistake. Right. So I would think that's a good approach.
Okay. Thank you, Commissioner Park.
But they also have listened well, and we can talk to them.
Right. Commissioner Blau?
Yeah, the only thing I have almost never opposed a continuance when there was good reason for it, or even if there's not good reason for it. And this one, I think there is maybe some good reason for it. However, I would want to hear from the applicant to get some idea that they would be agreeable to the continuance and be agreeable to some of the modifications that both you and Commissioner Park are wanting. You know, in the very beginning, when we were trying to design the ordinance, I was one that said I didn't want LUPs. I wanted everything to be a CUP because I didn't believe staff had the understanding or the commission and where would go on doing conditions. The idea being if they were all CUPs going through us, after a year's worth of approvals of these projects, there would be a standard that we would develop. That's not happened. What's happened is the majority are LUPs, and so they're all getting appealed to us. They're all getting appealed to the board, and so we're now kind of starting to write the rules. I'm not. If a continuance is going to make all the parties a little bit happier and make a better project, I'm all for it. But for me, I would really love to hear from the applicant to say that, yeah, he would make some of the changes that Commissioner Farini suggested. Yes, they would relook at the odor control measures and maybe work with Commissioner Park to put those necessary devices in. I just don't like the idea of us coming up from the top and deciding what's going to happen on the project. I'd like to see the applicant and the staff come together with an agreement based on our suggestions, as Commissioner Farini put it. So based on that, I was definitely support a continuance. I'd like to make sure that the applicant and the staff agree on the time frame, and also if there is some agreement on the suggestions, for example, that Chair Farini made, and the direction that Commissioner Park is going for. Absent that, I'm ready to approve the project. I don't care if it's a 3-2 vote. Let it go to the board and let them decide. The board didn't take my suggestion on odor control ever from the beginning going forward. So it's kind of like if odor control is the issue, then I guess they're in charge of it and they can decide what they want to do.
Okay, thank you. Commissioner Bradley?
Oh, I was going to say the same thing, so maybe you can ask Mr. Peterson to respond, I guess.
Okay, very good. I'll just add, I look at this as a conditional use permit, and I think it is our responsibility to come up with the best project. And for me, just denying it or shoving it through on a 3-2, I don't think that's us doing our best. I'd rather see our commission come together, get everything in this project that we think is best for the project and the community. And then we've earned that big pay we get. This is why we get the big bucks, guys.
Yeah, baby.
And Director Plowman, I'm sorry. I know I'm supposed to get this stuff done in one shot, but it looks like we're headed towards a continuance. So we're looking for the applicant to respond.
Chairman Farini and members of the commission, we're willing to work on further refining the odor abatement plan as has been discussed today. And, we're looking to work with the community here, not against the community. So if there are some things here that need to be refined and improved, we're very willing to do that during this continuance time. I might ask for a little bit of clarification and direction. A lot of ideas have been thrown out here as to what you do want us to work on. I think I'm clear on the OAP being more explicit in the adaptive management component. We'd like to know what else that's been talked about today specifically you'd like us to work on, and then we're happy to do that.
Okay, thank you. So now we'll go to staff, and who wants to be the lucky staff member?
I'll jump in front of staff, save them the pain.
Thataway, Mr. Wilson. Thank you.
So Chair and Commissioners, my recommendation, it sounds like we're discussing a continuance. Appreciate Mr. Peterson showing some willingness to collaborate with staff and the neighborhood on this item. My recommendation is if there is a motion for continuance, that there is some specific things that the commission directs staff and the applicant to work on. There was some ideas that were mentioned. I think Commissioner Cooney had also mentioned some thoughts. And if we could, to steal from you, Commissioner or Chair Freeney, develop a checklist or punch list of items that would support the commission or the majority of the commission making that finding of neighborhood compatibility. I think that would be helpful for staff and the applicant to be able to go back and work on. In addition, looking at the agenda and schedules that are going out there and to have enough time to collaborate with the applicant, we had asked for the continuance to be around July 14th to allow for those changes and revisions to come back before the commission. So that's my thoughts, Chair Freeney, as far as how to proceed.
Okay, very good. I'll start with the punch list. So item 1 is in the top grow area, no hoop houses. Okay. Item 2 was preserving as much of the bordering citrus trees around the grows as possible. Item 3, I'll need Commissioner Park's help with this, but there's mention of the private road is too narrow. What would it take to widen that road to where it was 2-lane? And that covers my concerns. Commissioner Park?
Wow. Really?
Let me add to those. Go ahead. The first thing, and I think it's obvious to the applicants, there's some inconsistencies in the project description and the OAP and things like that. I think you'll want to just tighten that up anyway. It's just kind of like doing a final draft. Okay. So tighten up the project description. I would agree, eliminate or reduce the hoops. Eliminate or revise Field 4 in some manner. And Commissioner Freeney's talked about to some degree. Tighten up the adaptive management plan provisions. You'll understand the ones we're talking about and refine that. With respect to the road, I think that would be wonderful if we could wave a magic wand and improve it. That would be a pretty major effort considering all the different landowners. I think the road's something we need to be concerned about when we're talking about, can we make the finding for compatibility? I don't know if we can fix the road in order to do that. So those are, that's my addition or revision to the punch list, which sounds like we're pretty close, Chair Freeney.
Okay, great. Thank you. Commissioner Blau?
Yeah, I was just going to tell you, a 20-foot wide road is what we would be. Don't guess unless the fire department has some other deal, but a 20-foot private road is adequate for fire departments and adequate for traffic and everything else.
Okay, so if they could get back to us and let us know the width of the road and if there were any more easement to allow it to widen to 20 feet, if it's
that's all you need.
Yeah. Okay, great. Commissioner Bradley?
When you're talking about the road, you're talking about the private road section that we're asking this applicant to single-handedly improve potentially, even though it benefits everybody else. Okay, so and the hope is to confirm that it's probably a 20-foot wide easement. And gee, that actually does set me back a little bit because I don't think that this case is going to generate the kind of traffic that would require them to burden that the entire length up to the driveway. I want to know that the whole commission wants to do that because that's costly.
I don't disagree with you. So it's a gravel road. It's a base road. I would just like us to understand what would be involved. It may not be an ask, if it comes back and it's 2 miles and it's 10 feet wide and it's going to cost $2 million, then no. It's just a better understanding of what's there. My feeling is most of the road is 20 feet wide, actually. I would just like it explored a little bit. Commissioner Cooney?
Thank you, Mr. Chair. I just elaborate on the odor abatement plan. One of the things that I think relying on the compatibility issue, the crucial issue that we need to find, it would be very helpful to indicate that the odor abatement plan target for protection is and detection of odors would be residences within a reasonable distance of the project itself. So instead of relying solely on the language of the ordinance, which talks about property that's zoned residential, we take into account the residences before you get to the residential zone as covered by the odor abatement plan.
Okay, thank you, Commissioner.
I got to weigh it and say I'm not sure I'm going to be able to agree with that. I mean, the idea being is if you're going to put a residential property on an Ag 2 zone, next to an Ag 2 zone, I don't have quite the same concern for the odors on that residential property. So I would look at it when it comes back to us after the continuance, but I can't foresee forcing an ag operator to have the same concerns and same requirements if he's next to, an R1 or an R10 property, as opposed to having a residential property on an Ag 2 property. I'd have to think about that.
Okay, thank you. Commissioner Park?
I'm going to address that odor piece that Commissioners Blau and Cooney have just discussed, but also get back to the road and what Commissioner Bradley discussed. On the odor, the ordinance literally says for residential zones where OAPs are required for those kind of projects. We look at that in Carpinteria, and it's sort of a zero tolerance thing that, if there is an odor, then you got to stop it. You got to deal with it. And I kind of agree with Commissioner Blau. That's a harsh thing to do in rural areas. And I wonder if it's even possible at all. So for me, when I'm looking at this from the most practical way I can look at it, is do your best to reduce the odors. And that's the whole point of these adaptive management plans and conditions. I don't know if one could ever achieve that goal of eliminating them. Now, getting onto the road, I think one obvious concern about a road is cost, and I think that's what Commissioner Bradley was getting at, is it fair to impose that cost on one party or not? There's another thing to look at too, and that's just the legal complications. I'll bet Commissioner Cooney has run into this as well as I have. In Montecito, just getting a road maintenance agreement sometime through 4 or 5 properties up a private lane seems like rewriting the Bible. It's just, it can be very complicated. And here, I know there's one vineyard that's kind of most of the way along that road. And maybe there's just one easement or one property that you hold an easement over, or maybe it's several. And so I kind of agree with Commissioner Farini that it's worth looking into, but not sure that we need to ask it. We kind of need to find out that complication. And if the complication is there's 20 different property owners, the odds of getting easement changes and all that to go to a wider road might be very hard. Or maybe the easement's already a 30-foot easement and you just have to bulldoze it some more. I don't know. We can't know today. So I hope that helped.
Commissioner Bright.
And I'm ready to make a motion just to simply continue this now that everybody's heard what the concerns are. Or do we need to talk about it some more?
Well, let's Commissioner Bribely's up, and then but we're close.
Yeah, we're super close. Just the other thing that I forgot about was that it's a private easement. I don't know that the county has any jurisdiction whatsoever over what happens on that gravel part of it. I guess we could, as a matter of the, linking it through the land use, entitlement, but it's not a county road. We can't do anything about it. I'm not even sure what we can control on it. So, because it's privately held. I mean, in fee title, it's probably held. So anyway, I think the direction is, it would be great if the applicant looked into it and, confirmed its width and just gave us a report. And if there's any improvements they can make, that would be great. But it's not a deal killer one way or the other. That's how I feel. I think that's what I heard from Commissioner Park and Freeney too. So, okay.
Yes, that's it. Let's take a look. Mr. Wilson.
Chair Freeney and commissioners, a couple items. I do want to manage expectations. I think I concur with some of the discussions. I think the best direction on the road is we will look into that with the applicant. I just want to manage expectations there. We can come back with information in regards to the road. I have concerns about requiring anything on that road at this point because we don't have enough information.
Since you brought it up, Mr. Wilson, since there's a home built up there, wouldn't the road have to meet fire code and be 20 feet wide anyway? In fact, there's 2 homes up there.
Yeah, Chair Freeney and commissioners, I will commit to looking into the road.
Okay. There you go.
And come back with more information. And then on the other things on managing expectations, as far as I think we've got instructions on improvements, revisions to odor abatement plan, use of hoop structures and potentially distances from property lines that we can explore with the applicant. I am getting messages from staff about the date. There is a list of items that we're being asked to explore. So I want to make sure that the date that I casually threw out earlier works for staff and the applicants. I think July 14th. We want to make sure the applicants they can meet that deadline because we would need to have pretty much everything in by the beginning of June in order to meet our schedules to bring it back to the commission. So if we need more time, and if the applicant would like more time to explore some of these changes and information that the commission's asking, we may want to look at August or the end of July. I just want to make sure we come back with a good product for the commission to review. So we might want to ask the applicant to come up and provide some information as far as dates that are available to them. So the dates at August 4th, it's wide open at the moment. And then the date that we would need probably everything turned into staff would be the beginning of July for us to start writing our memos and having that reviewed. So that gives about a month for the applicant team to work with staff to come up with a response to the commission's request. And that could actually be feasible. So Chair, if we could get some feedback from the applicant, that might be helpful on that.
Okay, Mr. Peterson.
Chairman Farini and commissioners. I'm trying to gather feedback from our different consultants and their availability here. August 4th would work for us to do that and work together with the staff and the community on these items that you've raised. I got 6 items written down.
Hang on 1 second, please.
I got 6 items here.
Dan, can you mute?
You want to do this by phone or hang on a minute here?
There you go. Okay. Sorry. Mr. Peterson, go ahead.
Sure. Thank you, Chairman Farini. have the issues as a reduction in hoop houses, looking at a potential reduction or elimination in the cultivation area 4 that's next to the Johnson's house, refining it and improving the language in the OAP as relates to adaptive management and kind of the 4 prongs of adaptive management Mr. Shatillo was mentioning. Preserving bordering citrus trees, and reconciling any inconsistencies between the park description and the odor abatement plan. All of those things we can on and are happy to do so. We're nervous about the road idea because obviously road's been a problem for a long time. Part of it's private, and that's a kind of a massive undertaking. So if you wanted to request of staff that they come back with a little bit of information on the status of the road, we would read that rather than sending us as applicants out to investigate the condition of the road, the width of the road, and potential improvements that could be made on it and what those would cost. That's a little bit more than we'd like to bite off. So everything except the road, we'd be more than happy to work on.
Commissioner Bradley?
That sounds good to me. Can I move to continue this to August 4th? Was that the date that Mr. Wilson gave us?
And I'll second it if she does that.
Okay, it's Commissioner Parks.
Oh, I'm sorry.
District, and
You're
also he did have a preliminary motion in. I just want to add this in. I get it on the road thing, but it's 1.5 miles. Just have somebody go out there and tell me how wide it is. I don't.
Well, it's not a road that you have to put in there. It has to be all surface, an all weather surface. Done in 10 minutes. So if it's not an expensive roadway, it may just need to be gravel or base or that sort of thing. So it's not the cost of a roadway.
No, I think the road's 20 feet wide. We just want to verify that.
Yeah, I think that's correct. Yeah.
Yeah.
And I apologize, Mr. Chairman. I actually withdraw my motion. It is Commissioner Parks. I didn't mean to get so excited that we were almost there. I apologize. Withdrawn.
Okay, it's 5 o'clock somewhere. Okay, Commissioner Park.
See, I don't even think it's my district. I think you redraw my district every meeting to make sure that all the controversial cannabis projects wind up as District 3.
Yes, Secretary Wilson's been cooperating well with me on that. So we're going to keep that going.
But whatever. So I'm going to move that we continue this matter to August 4.
I'll second it still.
There we go. Okay. Very good. Mr. Villalobos?
Commissioner Cooney.
Aye.
Commissioner Bradley.
Aye.
Commissioner Park.
Aye.
Commissioner Blau.
Aye.
Chair Farini.
Aye.
Motion passes 5-0.
Thank you, Mr. Villalobos. Mr. Wilson, do we have anything else some date we need to reset or cancel or anything? Or are we all good?
Mr. Chair, Commissioners, I think we have concluded all of our business for today. Thank you.
Okay. Very good. All right. Thank you.
I'll put down a break, Chair Farini. This is one I'm going to remember.
Yeah, I missed that. What was that?
Hey, we had lunch. Okay.
Yeah, that's true. 1 o'clock is when we started again. Good. You guys are younger than I am.
Okay. 1.5 hours maximum next time. Okay.
Thank you.
See you all. Thank you.